Yes. Why at 2? After motion matters, we'll take up the order matters. You wait. Yes. That's paid for me by Mr. S. Manik. List the matter again. After a week. I'll give a date after a week. No, just a minute. 11. What is 11 December? It's Wednesday. Why is it listed for orders today? Otherwise? Ah. Uh-huh. The view perhaps might change. Therefore, no, we'll have it on 9th, Monday. Why? No. We'll wait for you. You do your matters. Item on. We'll have it on Monday. This bench is available till 13th. Make use of it. Yes. I'm fixing on 9th. If you have difficulty, we'll accommodate you at 2 o'clock that day. Make a mention in the morning. Yes. By 1 o'clock also it will be. We try all our efforts to getting this if my not permits. Have you filed it? When did you file it? This morning. How can you get it listed immediately like that? No. The thing is that you have to be fair. You see, there are a number of cases waiting to be listed for motion. What's so special about your case? On the basis of this petition, there's a point operating saying that if I'm the principal caregiver, I need not be shunted out of station. Now, it's not the only reason I say you send me to Patna. I requested that you are acceding request to other persons also. They maybe have been transferred to directly Guwahati to Shillong with the posting at Bhubaneswar. These are things happening. No, it's a transfer matter. Bearing on my child who's sick, I just don't know that. They take into consideration that part. That's all. They allow people to sit in Delhi, sit in Shillong, and operate from Bhubaneswar, Coimbatore, and anyway, whatever it may be. Not today. Any other day. Not. Because they would do it by the end of the day. They would issue an order. I do that. At the time of certain copy, I do this one. Therefore, I do that confident. Let me try it 1 o'clock. 2 o'clock, whatever happens, if I can get it on, not today. We'll have it tomorrow. Then in that case, status quo when? Without seeing the No, I'm permitting you for the matter to be listed tomorrow. We cannot pass any order like that. Tomorrow you may persuade me, may not persuade me, whatever it may be. Whatever it may be, we'll have it tomorrow. Yes. Why? When was it last listed? Maybe not tomorrow. You're filing it or you have filed it? You filed it today. The parliament proceeding does not end in one day. It takes months and months, years. What is the hurry? What is the urgency? What is the urgency?
There are some matters which was pending before this division bench on that issue. Are you aware? Whether it can go side by side or it should not go at all. Something like that. Somebody had mentioned last time. You find out. Somebody had mentioned that there is an issue which is seized by a division bench regarding whether criminal and proceedings and department proceedings can go simultaneously on the same set of facts, whether it'll cause prejudice to the proceeding in one case. So what has happened to that case? What stay? Stay what? Stay of department proceedings. So you're saying that you're covered by that? Are you covered by that? No. Today is what? Monday. Okay, we'll see it on Wednesday. Tomorrow's a hearing day anyway. Wednesday. Yes. Next. What about the pleadings? Is it complete? Pleadings complete can be heard. Admission stage. When was it last listed? March. Okay. Affidavit was filed after that or before that? Then why was it not taken up in March? Parties were not appearing. That's why. So why you want to get it listed now? Again, parties will not appear. Okay, we'll have it on Friday. Hmm. 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 Okay, Friday. Hmm. Wait, 53. D Das for what? Respondent. His name is not there. Hmm? No, Mr. D Das' name is not there in the cost list. One BJ Josh is there. BJ Ghosh, then Ruby Gogoi. Okay. You're led by whom? D Das, senior advocate. Mr. Diganta Das. Okay. Miss B. Gogoi, learned counsel for the petition. Sorry. Miss R. Gogoi, learned counsel for the petitioner, submits that she's led by Mr. D. Das, learned senior counsel in the matter. But since he has some personal difficulty, the matter may be adjourned for a week. Prayers not opposed to by the counsel for the other side. In view of all, list the matter again after a week. Please come. List on the 11th. Hmm. Okay. Friday. Hmm. Okay, as paid for by the counsel for the petitioner, counsel for the respondent, Mr. S.K. Chakravarti, and not opposed to by the other side. List the matter again after a week. Yes. 37. How much time? As paid for, a week's time is granted to the petitioner to file rejoinder affidavit. Yes. 40. Okay. Tenth, as paid for by the learned counsel for the respondent. List the matter again on 10th of December 2024. Stop in the meantime. Let counter affidavit be filed. When was it last listed? It's been listed every month, seems. Okay, Friday. Next. $31. What do you want? Okay, as paid for by the learned counsel for the respondents. Matter stands adjourned for a week. Yes, counsel for the petitioner has no objection. 22. What do you want? 22 as paid for. You're for the petitioner. As paid for the learned counsel for the petitioner. Matter stands adjourned for the day. Yes. What do you want? You're for the petitioner. Which respondent? You have taken the consent as paid for by the learned counsel for the appearing for the water resource department and not objected to by the other side. The matter stands adjourned for the day. Day after. Yes. Hmm. Hmm. 16. As paid for by Mr. H. Alia, learned counsel appearing for the finance department. 2 weeks time is granted for filing counter affidavit. List the matter again on 16 December. Friday. Friday. Hmm. Hmm. For what? For listing. Okay, we'll see on Friday. Yes. He's called a Jamadar. He's called a Jamadar. Yes.
Lordship, item 1 was against an order of suspension. Subsequently, item 2, Lordship, they had initiated a departmental proceeding. Against their item number 2 was challenging that. Lordship, therefore, in item number 2, notice has been issued and there is an interim order staying the departmental proceeding. So, in item number 1, notice has not been issued. Therefore, if there is notice may be issued, let them file their affidavits in the matter. In item 2, notice has been issued and the proceedings have been stayed. The department is there. No, Lordship.
After vacation,
After vacation, Lordship.
Lordship may fix it after the vacation, Lordship.
Item 1 notice is yet to be issued.
I understand. What I was asking was, that interim order is still next date or,
Till the next returnable date, Lordship.
let's see. You are Mr.
A Chakraborty.
Mr. A. Chakraborty, learned counsel for the petitioner. Issue notice of motion returnable by 4 weeks. Mr.
A Kalita,
A. Kalita, learned,
for
stand-
standing counsel for industries, commerce and PE department.
standing counsel, industries and commerce.
And PE department,
What is PE?
public enterprises.
And standing counsel, commerce and industries and PE department. Accepts notice on behalf of
All the
all the
respondents.
respondents. Stop. As such, comma, no formal notice is required. Stop. However, petitioner to serve requisite extra copies of the petition within 2 days. List the matter again. After 4 weeks, along with WPC number 2066/2024. Then in 2066, please write in view of the order, as paid for, list the matter. Again, after 2 weeks, along with WPC number 419 of 2024.
4 weeks.
Interim order passed earlier shall continue till the next date of listing.
4 weeks, let's say.
4 weeks.
4 weeks.
4 weeks.
Obliged.
Publish.
Hmm. Item 3. Is the microphone on? I can't hear you. Just tap. Hmm. Yes,
This matter relates to non-compliance of order dated 15/2 of 2024.
page.
Page number 12, Lordship, this is the order.
What was the direction?
Next,
You are supposed to submit your
yes,
documents.
Lordship, we
Have you?
submitted a doc-
When did you submit?
This annexure number 12 on 8/5 of 2024.
Annexure number 12?
Annexure number 12, page number 21.
There is no annexure 12.
Annexure 2, sorry, Lordship,
Annexure 2, yes.
page number 21.
Your good name?
Yunanda.
Part Miss Nanda, learned counsel for the petitioner who submits that despite the direction passed by this court, by order dated 15/2/2024 in WPC number. This is a common order.
Two read petitions are there, common order is there. 6365 of 23.
Passed in WPC number 6365/2023
56.
and 5649 of 2023. The same has not been complied with by the respondents. Issue notice returnable by 4 weeks. Petitioner to take step for service of notice upon the respondents by registered post with AD within 3 days.
Obliged.
Item 4,
Made the Lordship.
Lordship, the order not complied with the page number 14 and the relevant page is 17. And on the direction, the SLC for taking a fresh consideration of the recommendation of the DLC of Pachar, district is meeting in respect of so and so. When though there are certain communications thereafter, but the final outcome or the final
Have you served a copy?
Lordship at page 18.
Okay. Heard Mr.
MH Lordship.
M.H. Laskar, learned counsel for the petitioner who submits that the order dated 9/1/2023. Just a minute. Was any time frame given?
No, your Lordship.
Not given.
Not-
Are you forgetting to mention something? This order is dated.
9/1/2020.
Today is what date?
Today is 112, 212,
2/12,
212.
2024. So more than 1 year now.
No, your lordship, there were certain communications. The order has become contempt starts into your lordship because the last communication lordship will get at page number 21. What happened? This matter was directed to be considered by the SLC. The SLC asked the Panchayat department to furnish vacancy position, which is at page number 19. Then thereafter, the last communication of what we have come to know is at page 21. It was made on 10/11/2023, whereby it is saying that vacancy were available. But thereafter, your lordship, nothing has
Just a minute.
lordship.
Order was passed,
On 9/1,
then order was passed on 9/1.
your lordship, there was
9/1.
no time frame as such was given in the order.
No time frame. Okay,
Lordship.
fine.
Yes.
9/1 order was passed. Then
Lordship.
you served a copy on
23/2,
23/2.
23/2.
Thereafter, what is the development?
Development lordship will get page number 19. There was a communication dated 14/9/2023.
Yes, by whom?
It
To
was
whom?
by the Joint Secretary to Government of Assam Panchayat Department to the Chief Executive Officer Jila Parishad Kachar.
Yes.
He was directed with reference to the subject site and letter cited above. I am directed to state that the proposal of Sri Afsar Hussain Laskar, son and so, has been placed at SLC on 7/9/23, and clarification has been sought regarding the cadet rank of grade 4 post as well as vacant post of grade 4 meant for compassionate appointment under PNRD department in connection with the materials furnished to the DLC. So a clarification was sought regarding vacancy position. Thereafter, at page 20, we find that there was a reminder again to the CEO. That was by the Deputy Secretary to the Government of Assam. Then pursuant to that, your lordship, the CEO by letter dated, which is at page 21, it is a type copy, 10/11/2023. He has informed that there are vacancies available. And thereafter, your lordship, we have no. So virtually, initially, there were some attempts to comply with the order, but after 10/11/2023, this was a letter by CEO to the Deputy Secretary of Government of the Panchayat and Rural Development Department.
(10/11) was the last letter.
That is what, yes, 10/11 was
And you filed the contempt on 26/11 after 1 year.
26/11.
So
So 10/11, but your lordship, there is no time frame as such
No.
given. That within this
limitation
time-
is one year, isn't it?
Yes, yes,
As per the Contempt of Courts Act.
lordship, 1 year.
After 1 year, how can you file all these things?
This is the fourth round of litigation the petitioner is fighting, your lordship.
Forget about 9/1. We are taking that date which you have just
Lordship-
saying.
lordship,
10/11.
10/11, 10/11.
Even if you go by 10/11, your petition is hit by delay.
But 10/11 was the communication, then there would be some period of time that the authority ought to have taken.
What some
consideration.
period of time?
And even if there are some communications thereafter, because this was a letter by the, to the Panchayat Department. Panchayat Department ought to have furnished it to the Chief Secretary, who is the Chairman of the Compassionate Appointment Committee, SLC.
What did I say? Has not been complied with by the respondent authorities, despite a copy of the same having been furnished. Issue notice returnable by 4 weeks. Petitioner to take steps for service of notice by registered course with ADDU. Within 3 days. I said respondents, no? Strike out S. There's only one respondent.
I'm deeply aware.
May I please your lordship, it's a contempt case, my lord. Honorable court's order is at page 12, my lord. Relevant direction is at page 20. Para 13.
What was the direction?
My lord, direction was, my lord, to give a notional pay, my lord, from the date of earlier High Court's order, my lord. But my lord, that order was on 5/8, my lord, August, but 3 months lapsed, my lord, nothing has done, my lord. That's as was remainder also, my lord, given as page 27, my lord. But no communication has been made, my lord.
Heard Mr.
C. Goswami.
C. Goswami, learned counsel for the petitioner, who submits that the order dated, judgment and order dated 5/8/2024, passed by this court in WPC number 5123 of 2020, has not been complied with by the
Respondent, my lord.
respondents, despite a copy of the same having been furnished to them. Issue notice of motion returnable by 4 weeks. Petitioner to take steps for service of notice by registered post with ADP within 3 days.
Public.
It says.
Yes.
That's it for non-compliance of this order. Daily
Page-
portion is page 22, you know,
23,
22.
22. What was the direction?
Thus, direction was given to the SLC to consider the case of the petitioner in his life next immediate sitting, if not already considered. If the
When did
case
you
of-
serve
I
copy?
served lordship, page 23,
Any time frame?
immediately.
Heard Mr.
Elmo.
L. Mohan, learned counsel for the petitioner, who submits that the order dated 21/2/2024, passed by this court in WPC number 871 of 2024, has not been complied with by the respondent, despite a copy of the same having been furnished. Issue notice, motion returnable by 4 weeks. Petition to take steps for service of notice by registered post with ADP within 3 days.
I did so then.
Which is your lordship? My lord, order is at page 13, lordship.
Yes, what was the direction?
My lord, direction was to consider the case of the petitioner lordship under the regulation 38 of the lordship, Assam Gramin Bikash Bank regulation lordship, for granting the pension lordship, family pension lordship.
Who was supposed to consider?
Respondent number 1, 2, 3, lordship,
Okay. Heard Mr.
NH Borbuyan.
NH Borbuya, learned counsel for the petitioner, who submits that the direction passed by this court by order dated 11/12/2023 in WPC number 7627/2022 has not been complied with by the respondent authorities, despite a copy of the same having been furnished to them. Next para, issue notice returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with ADD within 3 days.
Obliged.
I did it.
So the claim of the petitioner for family pension has not been considered by the respondents in spite of the court's order, my lord. My lord may see in court's order page 9 and the relevant direction, my lord, may see in page 11, para 7.
Read.
Considering the submission of the learned counsel for the parties and upon careful perusal of the writ petition, this court is the view that since the representation is stated to be pending before the BEO Dhubri dated so and so, and the said representation has not been disposed of, this writ petition is closed at this stage without issuance of notice, directing the BEO Dhubri to
Okay,
expeditiously
okay.
verify.
Have you submitted the copy?
Lordship,
When?
Lordship, page 12, my lord.
Page 12. What is your good name?
M. Aliman.
Heard Mr. M. Ali, learned counsel for the petitioner, who submits that the direction of this court by order dated 21/2/2024, more particularly in paragraph number 7 of the said order, has not been complied with by the respondent. How many respondents?
2 respondents, my lord.
By the respondents, despite a copy of the order being furnished to them. Stop issue notice of motion returnable by 4 weeks. Petitioner to take steps by registered post with ADD within 3 days.
Obliged, my lord. Thank you.
I did my.
Make these along.
Yes.
They have not complied with the order dated 12/9/2024. Page 45 is the relevant portion, Your Lordship. May I read?
Yes.
With regard to the opinion that there is some degree of negligence on the part of the petitioner, the question would be as to whether the penalty of compulsory retirement is a major penalty imposed upon him is commensurate with his actions or inactions. The same under the facts and circumstances and the considered view of this court appears to be excessive by applying the principle of law laid down by the apex court in Deputy Commissioner
Kendriya Vidyalaya Sangathan and others, Supra, this court thinks it fit to remand the matter back to the disciplinary to reconsider the penalty imposed upon the petitioner and for imposition of a lesser penalty other than compulsory retirement. According to the imperial orders dated 3/4/2021 and 4/7/2023 are hereby set aside and the matter is remanded back to the disciplinary authority to pass necessary orders as observed herein above within a period of 4 weeks from the date of receipt of a certified copy of this order. In passing the orders as directed, the disciplinary authority shall also pass appropriate orders in respect to the entertainment of the petitioner for his reinstatement. With the above observation and direction, the writ petition stands disposed of and the parties are likely to bear their cost. Then your lordship may kindly peruse page 47. We file an presentation on 13/9.
The copy is given to the government advocate.
Yes, your lordship.
Shouldn't- Okay, the petitioner he's a
Employee of the
employee of
High
the-
Court. Yes,
okay.
your lordship.
Now, what will be the steps, appropriate steps? Yes.
They ought to have considered the case, your lordship. They have
No,
not
no.
done it.
No, who's the authority to consider it? Who's the authority?
The senior government advocate, your lordship, is the appointing authority.
No, shouldn't it but done by the respondent numbers 1 and 2, legal remembrancer or the secretary?
I have made him a party also, yes, your lordship.
But you have not served them a copy.
No, your lordship. But he's the appellate authority, your lordship, the legal remembrancer. That is why I have not filed a repentance to him, your lordship.
Who's the disciplinary authority?
The senior government advocate, your lordship.
Senior government advocate is the disciplinary authority. Your good name?
T. Deori, your lordship.
Heard Mr. T. Deori, learned counsel for the petitioner who submits that the direction passed by this court provide judgment and order dated 12/9/2024 in WPC number 4258/2023. I repeat, 4258/2023 has not been complied with,
Notice this.
despite a copy of the same having been served to the disciplinary authority concerned. Issue notice returnable by 4 weeks. Petitioner will take steps for service of notice by registered post with a review within 3 days.
May I please, your lordship? Lordship, order is on page 15, my lord. Relevant portion is lordship, para 4 and 5, my lord. I have communicated the order, my lord, is 21, my lord, annexed to.
Have you served a copy?
Yes, my lord. Page 21, my lord. Annexed to me.
Okay, now there are 2 writ petitions, eh? Common.
Common order, my lord.
Okay, the petition is one and the same.
Same
person.
Same person.
What is your good name?
HL Ashkar.
Heard Mr. H.A. Lashkar, learned counsel for the petitioner who submits that the direction of this court white order dated 30/11/2023 in WPC number 2246/2022 has not been complied with by the respondent authority concerned, despite copy of the same having been furnished. Issue notice returnable by 4 weeks. Steps 3 days, same thing.
Most of them.
This matter may come after 1 week, my lord. I will submit the postal receipt, my lord. This is literally not
Okay.
annexed. After 1
Just again after a week as paid for by the counsel for the petition.
week. May it please, your lordship. May it please.
Yes.
Petitioner is serving as a junior assistant in the office of respondent number 4, my lord.
Huh?
Petitioner is serving as a junior assistant in the
junior
Okay.
assistant in the office of the respondent number 4, my lord.
Okay,
Gradation list was published in a draft gradation list, my lord. Where my petitioner, lordship will kindly see the that list, lordship will find at page 16, my lord.
yes, 16.
My lord, petitioner is a serial number 312, my lord. Himanshu Gogoi, my lord. My lordship, my lord, his initial date of appointment is 11/3/2015, my lord. The fourth column.
Yes, date of appointment 11/3.
Yes, my lord. And lordship will kindly come to serial number 328, my lord. That is my respondent number 5. His date of appointment is my lord 24/12/15, my lord.
Serial number
My lord 318, sorry, my lord, 318.
318.
318, my lord. Deepak Kumar Neva. His date of appointment, lordship will see that 24/12/2015, my lord.
Yes.
He is junior to me, my lord. And my lord, this according to the draft list, my name was placed above the respondent number 5, my lord.
Hmm.
Now, lordship, they issued final list, my lord. That your lordship will find it page 19.
Yes.
In the my lord, final list, lordship will see, my lord, petitioner was placed at serial number 317, my lord.
317.
317, and respondent number 5 was placed at my lord 314.
Respondent number
5, my lord.
5.
Yes.
314.
314.
Hmm.
Lordship will see there is no change in the my particulars, my lord. My date of appointment is my lord 11/3/15, my lord. And his date of appointment is my lord 26/12/15, my lord. And my date of confirmation is my lord 17/20, and his date of appointment confirmation is 19/19/2023, my lord. It appears there is some mistake in preparing the final list, my lord, and I have been placed below the respondent number 5, my lord.
This is a gradation list.
Yes, my lord.
Of
My lord,
which post?
my lord, ministerial staff, my lord.
Sorry?
Ministerial staff. my lord.
Ministerial staff.
my lord.
Under which establishment?
Commissioner of Taxes, my lord.
Okay.
The respondent number 2, my lord.
So you are challenging this
Respondent number
final
Yes.
gradation list.
Yes, my lord. I submitted representation, lordship will find it page 22, my lord.
22.
Immediately, I submitted on 11/11/24, my lord. That is pending with the respondent number 3, my lord. Can be disposed of, my lord. They can consider my representation. Apparently, I am senior, my lord.
Who is responsible for preparing the gradation list? Respondent number 3.
Respondent number 3, my lord. He has issued this, my lord.
So we'll dispose it of.
My lord.
How much time?
They will say whether 2 weeks or 4 weeks, outer limit of 4 weeks.
Heard Mr.
R.S. Mishra, my lord.
R.S. Mishra, learned counsel for the petitioner, who submits that the grievance of the petitioner is that as per the provisional gradation list of ministerial staff in the office of the Commissioner of Taxes, Taxation Department. His name appears at serial number 312. But in the final seniority list, final gradation list, which was published on 5/11/2024, he has been placed below the respondent number 5, who otherwise is junior to him and was placed below in the provisional list. He submits that the petitioner was initially appointed on 11/3/2015, whereas the private respondent number 5 was appointed after him on 26/12/2015. The learned counsel submits that being aggrieved, the petitioner has submitted a representation before the respondent number 3
My lord.
on 11/11/2024, which however has not been considered till date. So at this stage, he submits that the limited prayer of the petitioner is that his representation dated 11/11/2024 may be considered by the respondent number 3 and disposed of by way of a speaking order. Next para, Mr. B. Goel, Learned Standing Counsel, appearing for the Finance and Taxation Department. Submits that in view of the pendency of the representation of the petitioner, the petition, the same may be directed to be disposed of by the competent authority. Next para, in view of above, the petition is disposed of with the direction to the respondent number 3. Consider and dispose of the representation dated 11/11/2024. Bracket annexure D submitted by the petitioner within a period of 4 weeks from the date of receipt of a certified copy of this order. The petitioner shall also furnish a copy of the writ petition to the respondent number 3.
I have one small prayer also. Till disposal of my representation, my lord. Then my respondent number 5 may not be promoted, my lord.
No,
Then-
that, my lord, when such an initiative is initiated by the authorities, he can always come, my lord, if it is deprived.
It will not be.
Instead of, my lord, there is no apprehension.
Any process going on for
Yeah.
promotion?
I have the instruction, my lord. They are contemplating, my lord. I have made a statement also, my lord. If it will not prejudice to him, my lord. If till disposal of my representation, my lord.
You'll not,
Without hearing the other session again.
they'll take, you
Lordship
submit
will
the
make 3
certified
weeks,
copy.
Lordship will make it 3 weeks. We'll consider it within 3 weeks. Instead of-
Okay, make it 3 weeks then.
My
My
lord.
lord, if within 3 weeks it does not dispose of, my lord, then there shouldn't be promotion, my lord. It will also be observed. Otherwise,
No, no, no. That much will do for
my
now.
lord,
You
my
submit.
lord, my lord.
You be vigilant. If
My lord.
something happens, you come back.
Oblige, my lord, sir. It be oblige.
May I please, Lordship? Okay, in terms of the Lordship earlier order, we have received a preliminary instruction. Lordship, my submission is that Lordship may fix the matter before the vacation, Lordship. And in the meantime, we will file our affidavit, Lordship.
On a limited context, this matter has been filed, Lordship, is with regard to the ad hoc promotion of the petitioner. Now, what has happened, he has been inflicted with a major punishment. I have made that copy also. This is at page number 54, Lordship. That is with regard to withholding of promotion for a period of 18 months. That was in the year 2021, Lordship. Now that period is over. Now repeatedly is pursuing the authorities. And on the basis of some criminal proceeding which is going on against the petitioner, that has been delayed. But there is a procedure on the part of the respondent also, that there is a provision for ad hoc this promotion.
Yes,
So
Lordship.
I'm just praying for the ad hoc promotion of the petitioner, Lordship. That
That's
is the
why
simple
we
thing
have
I'm just
received
praying.
instruction. Lordship may fix the matter within.
Because
Lordship,
DPC is
before-
going to
before the
held
vacation,
this
Lordship.
month, Lordship. So if the DPC is
What is the petitioner working as?
grade C, grade B post, Lordship. He is praying for the grade C in the well, Lordship.
Grade
He's-
D.
Grade C, Lordship.
No, he's working as in grade D.
Grade B, promoted to the post of grade C. Lordship, kindly see my representation. In the representation, I made a mention with regard to this page number 56, Lordship, annexure 8. This is the engineering post, Lordship. I was eligible for promotion to grade C with effect from 1/1/2022. However, due to imposition of penalty of withholding promotion for a period of 18 months by the order dated such and such, the promotion of the undersigned was withheld and the undersigned was subsequently eligible for promotion from 1/7/2023, subject to vigilant clearance and no criminal proceeding. But there is a provision on the part of the well also, Lordship. There is a provision for ad hoc promotion. So that can be taken into account, Lordship, because there is no certainty when this criminal case will be completed. So if that be so, Lordship, he will be again prejudiced because last year also he has not been taken into consideration. This year also.
Yes.
Lordship, I have received.
What do you say?
Lordship, I have received preliminary instruction, Lordship. Lordship, what happened in this case, Lordship, see, the colleague of the petitioner, Lordship, filed an FIR against the petitioner, Lordship, alleging serious offense, Lordship, for under section 354D, Lordship, of the IPC, and FIR was lodged, and thereafter charges was framed, Lordship. And Lordship knows that as per KV's annual case, Lordship, para 16 and 17, the petitioner's case was placed under sealed cover procedure. Lordship, there is a policy of the sealed cover procedure, Lordship, of the petitioner's company, Lordship. As
Achha,
per that,
His case has already been considered.
Lordship, as
Already
a-
considered,
under
but kept in seal cover.
seal cover procedure. And there is a Lordship guidelines of the seal cover procedure, Lordship, wherefrom it is stated, let's say, all the time of the consideration of the cases for promotion, details of executives in the consideration zone for promotion, falling under following categories should be specified, brought to the notice of the Department of Promotion Committee for placing their cases as seal cover.
in 3 Lordship 1(3), the executive in respect of whom prosecution of criminal charges on serious allegations of corruption, bribery or similar grave misconduct, including moral turpitude, fraud, dishonesty, etc. is pending. Lordship. In this case, the petitioner's case is covered under the moral turpitude. Lordship. Therefore, the Lordship, if Lordship peruse the instruction, Lordship.
So when will it be opened?
Lordship.
Seal cover? When are you going to open it?
Lordship, the charges was framed, Lordship. The petitioner's charge was framed, Lordship. Therefore, as per KB Janakiran case, Lordship, seal cover procedure is already placed, Lordship. And Lordship, the criminal case is pending, Lordship.
Lordship,
Now,
learned-
after the FIR was filed,
Yes, Lord.
they have filed the
Yes, Lord.
charge sheet.
Lordship, charge sheet file after 2 years. So
Then after that, what has happened
cognizance
now?
of the cognizance of the offense has been taken this year only, 2024. That is also after a period of almost 1.5
And seal
years.
cover procedure was adopted
6
when?
months. There is a provision under the guidelines on seal cover procedure.
No, when was it kept on seal cover? When?
Lordship, yes, I am good. I think the petitioner was already intimidated about that thing. That's why, Lordship, I am paying for fixing the matter after 2 weeks, Lordship.
In their representation, Lordship, in their reply to the representation, Lordship, they have made a mention only with regard to the fact, since the criminal proceeding is going on, if your Lordship kindly see annexure 7, this page number 55. Because that amounts to double jeopardy, Lordship, because the major penalty was imposed and I was withheld promotion for a period of 2
Lordship, I have to take
2
instruction
years.
when the seal cover procedure is placed, Lordship. Lordship may fix the matter on Wednesday, Lordship.
Because there is a provision for review of the seal cover procedure is also there. When there is delay, then there is to review the procedure.
That's why, Lordship, as per the seal cover procedure,
I'm
Lordship,
just-
his case is falls under the moral turpitude, Lordship.
Lordship, I'm
And the Honorable Apex Court in the recent judgment also, Lordship, while dealing with a similar matter, Lordship, felt that in respect to the moral turpitude, the state is has the discretionary power to not to consider, Lordship.
Lordship, already major penalty has been imposed
Lordship,
upon
that
the
is- that
See,
is-
this is not a rapid fire round, okay, both of you. You listen also to the court. Now, thing is that you are challenging which particular, any impugn order
Lordship,
in this
I'm
writ petition?
basically I'm this particular order. It is at page number 55.
What is that 55?
Lordship, in that particular communication, the promotional aspect of the petitioner has been taken into account and accordingly it has been communicated is regulated by the penalty. If your Lordship kindly see the page number, the 55,
See,
the paragraph.
We'll do one thing. Why don't you file your affidavit in a
Yes,
position?
Lordship, that's why I'm bringing.
You've said so many things, but you have not filed any affidavit also.
Lordship, last occasion, Lordship, last week, Lordship, we have directed to take preliminary instruction, Lordship. That's why fix the matter before the vacation, Lordship, so that we can file our affidavit.
You file your affidavit so that we can dispose the matter
Yes,
also,
yes, sir.
like that. What was the point of having your preliminary instruction? What was the purpose? Preliminary instruction.
Yes.
You say that as per your policy,
Yes, sir.
decision, procedure, you are supposed to keep things in seal cover
Yes, Lord.
if there's some allegation against the person concerned. And he says that you have been prolonging this whole entire thing has been prolonged for the last 2 years. Somehow they have filed the charge sheet after the investigation. And 2 years he has not earned any promotion.
He is claiming for the ad hoc promotion, Lordship, as under the seal cover procedure. But the seal cover procedure has specifically prescribed one thing, that moral, in respect of moral turpitude,
You clarify that
yes, Lord.
in your affidavit. Whether such kind of order can be passed or not. Please write down, parties are represented by their respective counsels. So claim of the petitioner is for ad hoc promotion from Group B to Group C. Even during the pendency of the criminal proceeding against him. Stop. The learned counsel for the respondent suggests that since the allegation involves what is that? Moral turpitude. The petitioner cannot claim the benefit of officiating promotion. Stop. Be that as it may, let the instructions received by the respondent be filed by way of an affidavit within a period of 2 weeks.
Lordship, a date may be fixed, Lordship.
List.
Can it be taken on 15th, Lordship? In between that 15th of this month. Because the vacation is also coming. And the DPC will be held in the month of December also, Lordship.
15 is Sunday. 16th. 16th of December.
All right.
Hello.
That is your lordship. Matter relating to payment of retirement dues, my lord.
Retirement leave.
The retirement dues, those are dues are sanctioned amount, my lord. And petitioner is retired on 2022. A small portion has been paid, but a large portion is still yet to be paid. But in the meantime, my lord, for the VRS, my lord, a policy has been taken up to give some employee to VRS, and for them, fund has been allotted. But for us, nothing such is, my lord, there, my lord. And already, my lord, several case has been filed, and my lord, that in those notice has been issued, my lord.
Yes, my
So,
lord.
in
notice
this
has
case
already
also,
been
my lord,
issued in
notice
similar
may be
cases.
issued, my lord, and this matter will be taken up with those matter, my lord.
WBC 6234/2024.
And the order by which amount has been sanctioned is your lordship at page number 27, my lord.
This is the petitioner.
My lord.
What has been sanctioned? Gratuity, leave salary,
Gratuity, unpaid leave salary, CPF. These are the,
this is sanctioned,
my lord,
but
sanctioned.
not paid.
Not, a small portion has been paid, my lord,
How much?
56,000, my lord. 56,000.
Total is how much?
Total is, my lord, 20,46,354.
This is the balance or total?
This is the total, my lord. And
20,46,354.
yes, my lord.
Out of which you have given
Out of
56,000.
56,000 has been paid.
What is the reason?
No reason has been cited.
First, I will get the instruction. Similar matters honorable court
This
has
may be
issued
issued and this may be
notice
tagged with the other matters, my lord.
Your
6
good,
to 3.
your good name?
MAI Hussain.
Please write down. This is item 14.
Lordship 14, 15, 21 are similar matter.
Okay, just a minute. We'll pass one order first.
Lordship.
Item 14. Heard Mr. MAI Hussain. Learned counsel for the petitioner, who submits that this writ petition has been filed by the petitioner, seeking a direction to the respondent authorities to pay him his retirement dues. Stop. Referring to the sanction order dated 22/11/2022, bracket annexure 2. The learned counsel submits that out of the amount entitled to the petitioner, that is 20,46,354. Only rupees 56,000 has been paid to him. Now, he therefore submits that direction may be given to the respondents to disburse the remaining balance amount. Next para, issue notice of motion returnable by 4 weeks. Miss MD Bora, Learned Standing Counsel,
Transport.
Transport Department, accept notice.
Only for 1 hour.
Yes, for respondent number 1 and accepts notice. Miss,
J. Gogoi.
stop. Miss J. Gogoi, Learned Standing Counsel, SSC, accepts notice on behalf of the remaining respondents. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing. List the matter again after 4 weeks, along with WPC number
6234 2024.
I got it, 6234/2024.
Deputy Owner.
Now, same order will go,
Yes, my
15,
lord. 15.
15 and 20,
21.
21, there is my lord, some difference is there. My lord, the petitioner is the wife of the employee who already died. My lord.
give me 15 first. Since I've mentioned the figures, I think the figures will change.
Figure will change, my lord.
Item 15, you write,
Item 15, my lord, order is, there are 3 orders regarding the.
how much is the amount to be received by you?
My lord, in this case, my lord, I have received 1,45,000
Out of,
out of my lord, 19 lakh 55,665.
and what is the annexure?
Annexure is from my lord,
Sanction letter,
my
sanction
lord,
letter.
from 29, page number 29, it is the gratuity amount.
Oh, this is sanctioned in different orders. By
Yes,
way
my
of
lord,
different
there
orders.
are 3 orders, there are 3
It
orders.
is not a consolidated order.
No, my lord, it is a 3 order.
Then you write an order, please write it like
My
this.
lord,
Heard Mr.
MAI.
MAI Hussain, learned counsel for the petitioner, who submits that the petitioner has approached this court seeking a direction to the respondent authorities concerned to disburse the retirement dues of the petitioner. He submits that an amount of rupees 19,55,665 is due to the petitioner. But however, the respondents have only disbursed rupees 1,45,000 only. Next para, issue notice of motion returnable by 4 weeks. Ms. MD Bora, learned
Standing
counsel, transport department, accepts notice on behalf of respondent number 1. And Ms. J. Gogoi, learned standing counsel, ASTC, accepts notice on behalf of the remaining respondents. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing today for the respondents. List the matter again after 4 weeks, along with WPC number 6234/2024.
Item 20.
Yeah, my lord, petitioner is the wife of the employee.
How much is the amount?
Amount is, my lord, 28,80,740.
Please repeat again, how much?
28,80,740.
Where do we find that?
It is in page number 11. I have calculated all this thing. And there are also, my lord,
Page number,
page number 11. It is in the writ petition, my lord, paragraph number 9. I have calculated all the amount which was already
28. How much have you received?
I have received 1,06,119 from this 3 heads, my lord.
18 lakhs পাবো বাকি আছে না?
1,06,119.
1,06,119.
Okay. This order, it'll be same with item 15. 15. Similar order. Only the figure, I'll give you the figure, okay? Figure will be petitioner out of rupees 28,80,740, the petitioner has received only a sum of rupees 1,06,119. The remaining is same, okay?
It's similar to item number 14, not 15.
Item number 15.
14. 14. Yes.
14, 15, they are all
Yes.
similar.
Right.
14, 15, and 22.
21, my lord.
21, sorry.
20.
Hello.
Item 16.
May it please the lordship.
My lord, in brief, this matter pertains to my lord, non-payment of the salaries to the petitioner for last more than 16 months. These petitioners are regular employees of Assam State Agriculture Marketing Board and has been duly recruited by following the due process, my lord. Now, my lord, after working for more than 9 years, my lord, they are now, my lord, have the authorities for no reason have not released their salaries for last 16 months, my lord. Now, my lord, in between, there is a, my lord, there is a development wherein, my lord, this board, my lord, government was contemplating to close this board by offering VRS to the employees, including the regular and the contingency employees, my lord. So, my lord, these same petitioners had challenged the VRS decision taken by the authorities in another writ petition, wherein, my lord, a notification was issued, wherein it's mentioned that the petitioner should immediately opt for VRS without giving any clarity. Meaning thereby, my lord, there was a scheme in the VRS for redeployment. Now, these petitioners are very young, my lord. They have only 9 years of services they have rendered and more than 20 years are left. Now, my lord, this scheme says that they are entitled for redeployment. But immediately when petitioners ventilated their grievances by representation, the authorities have basically gave a U-turn and said that nothing doing, you will have to succumb to the policy and then, my lord, submit their VRS. That was put to challenge, and this court has protected the services of all the petitioners in that writ petition. And quickly, my lord, may I just take your lordship to that order, my lord. At page 92, my lord, it starts, my lord. And the relevant part starts from page 94, my lord. So on this particular day, on 9/8/2024, a status quo order was granted, my lord, with regard to the service of the petitioner be maintained till the next date. It is, however, made clear that the status quo would be reconsidered on the next date. My lord, may kindly peruse the order which was passed on the next date. This is the order, my lord. Wherein after perusal of the records, my lord, the court extended the status quo order until further order, my lord. Status quo maintaining the services, my lord, that they will not be removed.
You are serving as what?
As accounts assistant in Assam State Agriculture Marketing Board, my lord. We are regularly recruited employees in pursuant to an advertisement. I have given, my lord, the details of the recruitment process where we were appointed, my lord. I'll come to that, my lord.
So you have been deprived of 16 months salary
Yes, my lord.
because you are not submitting your VRS.
That could be a reason, of course, my lord. I
No,
cannot
that is not
contemplate.
right.
That could be a reason, because why I'm saying this, my lord, why after this VRS scheme, which was introduced by the government.
Why VRS?
Voluntary retirement, because they may have this, my lord, they are saying that they want to rationalize the manpower.
No, they want to close down the board or what?
Maybe, my lord, they have not come out clean and they have not come out transparent, my lord. It's completely opaque process, and that is put to challenge in this writ petition that I have madam mentioned, my
These
lord.
are a different set of employees.
They are the same employees, my lord.
No,
Yes, my lord. Kindly,
same
lord.
employees, they are employees of the marketing board.
Yes, my lord.
Other
Directly-
persons. Other persons have come earlier.
The same writ petitioners have come earlier.
Oh, same petitioners.
Same. That is the irony, my lord.
No, why you filed the second writ petition for your salary?
Non-payment of salary,
Okay.
which has not been released for last more than 16 months, my lord.
So we'll issue notice. What is that
Kindly, my
at
lord,
this
may
stage?
appreciate something like they should make some arrangement to release some
No, sir,
percentage
no,
of
sir, this is
the
only-
salary,
this
because,
is
my
the-
lord, these people are regularly working
No.
even today, my lord. There has been no complaint against them whatsoever, my lord. So they are running their family. Some kind of sympathy, man, they should have for these people, my lord. Otherwise,
You're working as on today.
yes, even today also they are working, my lord, because the
No,
court has
So
protected them.
under what provision are you withholding the
Yes,
salary?
my lord.
Lordship, what happened, Lordship, the marketing board earlier run by in their own source of revenue, Lordship.
Ah.
But from 12/6/2020, the collection of cess has been stopped, Lordship. 12/6/2020. After
12/6.
2020,
Collection of?
cess, Lordship, cess has been completely stopped, Lordship.
So from the
So-
from the collection of cess, you are paying salary.
Yes, Lordship, earlier. But after that, what happened, Lordship, now government give us some financial aid, Lordship.
Ah.
But due to non-receipt of the financial aid from the finance department, we are unable to pay salaries to the employees, Lordship. That is the fact. Otherwise, we will pay, Lordship. When we receive the fund from the government, we will pay, Lordship. The other matter is something different, Lordship. They already in the VRS scheme, Lordship, out of 754 employees, 607 employee regular employee and 147 employee already applied, Lordship.
So Lordship, at this notice will be issued, Lordship.
My lord, difficulties and our other case, he's trying to draw parity. I'm bringing the other case because we are duly protected by the court's order that will not be removed and the board is functioning smoothly. Even managing director is drawing his salary on a my lord, regular basis.
No.
But these are, my lord, accounts officer, my lord, serving regularly and they are deprived from their, my lord, basic salary, my lord.
In earlier case, Lordship, to really define, they challenge the VRS scheme, Lordship. In this case, Lordship, only they pays for the salary, Lordship. Till that we have not received the financial aid from the government, Lordship, so. we
I
are
just
able to
quickly
pay.
take my lord to the relevant part where my salaries has been stopped, my lord, at page
Yes, that is true,
109.
Lordship. They have not received the salary, that is true, Lordship. We are admitted it. But after receiving of the financial aid from the government, we will immediately release it, Lordship. But in this case, Lordship, finance even not yet even party, Lordship. Without receipt from the government, Lordship, we are unable to pay the salary, Lordship.
If you have no finance, then why are you employing all this?
Earlier, Lordship,
Employers.
it was
Hmm?
run by own source of revenue, Lordship. But government of Assam stopped the collection of cess from 12/6/2020. So the difficulty arises, Lordship.
See, the balance now, the dues which is works out into 6,77,000,
That is
8,15,000. How will you pay them?
Lordship, the
They are
government,
continuing their work.
Yes.
they are working, Lordship. The government of Assam will release the financial aid income more, Lordship, as
You
per
are-
my telephone instruction.
You are making use of their services, and again, you're not paying them also.
Also, we'll
Okay.
pay, Lordship. We'll immediately receive the salary, financial aid, we'll pay, Lordship. As per my telephone instruction, that in this month.
Mr.
Suppose-
Burgoyne, what can be done at this stage?
My lord,
Notice,
My lord,
apart from notice.
there is a question of financial paucity which they are trying to project, my lord.
Hmm.
There may be, my lord, I'm not on that aspect, my lord. Now, as far as these petitioners are concerned, at least some sympathy should be given to them in the light of the fact that they are selflessly, my lord, serving for last so many years.
Lordship,
my lord.
not only
And
the
they are
petitioners,
hardly bothered, they are only thinking how to close this, my lord, board.
Lordship.
And now they, as per my information, my lord, 132 employees they have. Other rest 612 total employees, they have given VRS. Now for 132, these present petitioners also included. So they don't even have to, my lord, pay for the remaining people who has opted for, my lord, VRS.
All right, notice will go at this stage,
Yeah,
both
this
in
is notice, sir.
both in the writ petition, main prayer and the interim prayer. By the next returnable date, you come with some instructions.
Yes,
Also,
ma'am.
I'll obtain instruction.
How much
As-
can
As
you
per my telephone instruction is
give
there.
them some amount?
Also, at this stage, it is not possible, Lordship. We have no money at this stage. Only,
Oh. Next date, you'll come back with some instructions.
Lordship, I will obtain the instruction. Telephone instruction is that the financial department will release some amount in this month, Lordship. That is my
Then
instruction.
obviously, you have no money. Otherwise, why should they come to the court?
Lordship.
They want to compel you to release the money. You also hard pressed. You also mobilize your resource. How to
The
go
government
about
of Assam stop this collection of sales, Lordship.
But that is a completely different chapter because they are about to close down the board, my
it.
lord.
Art Mr. H. Borogohain,
Yes.
learned counsel for the petitioners who submits that by filing this writ petition, the petitioners pray for a direction to the respondent authorities to release their salaries, which has not been done for the last 16 months. Issue notice of motion returnable by 3 weeks. Mr.
And they go.
N.J. Gogoi, learned
Sending council. Assam
Sending
State-
Council, Assam State Agriculture Marketing Board accepts notice on behalf of respondent numbers
5 and 6.
5 and 6.
I am for
Stop.
2, 3 and 4.
Miss
Zebora.
Z. Bora, learned counsel, accepts notice on behalf of respondent numbers
3 and 4 rotate.
2, 3, and 4. Who else? 1,
1.
Mr. Ad-hoc, learned additional senior government advocate, accepts notice on behalf of respondent number 1. Stop. As such, notice is complete upon the respondents. Petitioners to serve requisite extra copies of the writ petition to the learned counsels appearing today. Next para, issue notice on the interim prayer made by the petitioner, also returnable by 3 weeks.
I'm highly obliged. They may bring some instruction on a.
Lordship, I will file
next
a paper,
April or-
I will in that case, I will file a paper.
Learned counsel for the marketing board shall obtain instructions regarding the release of salary to the petitioners by the next date.
I'm
Obliged, sir.
highly obliged.
It's 17.
Yes.
A similar petition pending, similar issue, my lord. In this case, my lord, what happened, my lord? In a selection process, my lord, the petitioner is a disabled person, appeared, my lord. He selected, my lord, on merit, my lord. Then he was recommended by the SLRC for appointment. And after the selection process over, my lord, the competent authority, my appropriate government, my lord, they hold a medical examination, medical re-verification, means the reassessment of the disability of the persons with benchmark disability. And in the reassessment, my lord, the writ petitioner has been found, my lord, he has only the 30%, my lord. That is at page, my lord, 49. 49, my lord, medical report, my lord, and 50 relevant, CL number 15 and surveillance. Right side, my lord, 30% his disability. So he does not meet the threshold of 40%, my lord, for benchmark disability, my lord.
Yes, page 49. Where is that?
50, my lord, page 50.
Page 50.
Yes, my lord. Left side, serial number 15, surveillance command, my lord, middle on.
Serial number?
105, my lord. Middle
Yes.
on middle, my lord. Surveillance command, name of the petitioner.
Yes.
And last year, kindly see 30%, category 2.
30% means 30% disability.
Yes, my lord, 30% disability.
This is the re-examination.
Yes, re-examination result, my lord.
Earlier, how much was it?
Yes, as per the certificate issued by the certifying authority, who is the statutory authority, my lord, his disability is, my lord, at page 37. Disability 40%, my lord. This certificate has been issued, my lord, under the provisions of the Disability Act 2016, my lord.
Issued by who?
Issued by the Joint Director of Health Services, my lord.
Who is the competent authority?
Yes, he is the certifying authority, competent authority under the statute.
What is the problem? Low vision.
Yes, my lord.
What is the disability?
He
Low vision.
low vision, my lord. Low vision, he has no one eye. He only has the one.
He has only one eye. And the vision is also 40%. Or what?
Yes.
Or because of loss of one eye, he's
Not one, right? Another eye also there is some low vision.
acha.
Therefore,
He has only one eye, and the good eye also has low vision.
yes,
And so disability is 40%.
yes,
And on reassessment, the vision was shown as 30%.
30%. The issue is, my lord, here, the
And employment is for what post?
chowkidar, gate for post.
So what happened after that? After the re-evaluation?
All the candidate has been issued appointment order, but petitioner has not been issued the appointment order. Not only petitioner, the similarly situated who has been assessed below 40%, they have not been issued the appointment order, madam. But under the statute, my lord, 2016 Act, disability, madam, the concept of disability has been changed as the concept was in the 1995 Act. And the two new concepts has been introduced in the 2016 Act, my lord.
What is that concept?
That is, my lord, reasonable accommodation, which is also a new concept in India, my lord.
Reasonable accommodation.
Reasonable accommodation, that has been a right given to the disabled persons. And my lord, the reservation, this reservation of the benchmark disability, my lord, is a horizontal reservation within the reservation of PWD, which is also the horizontal reservation, my lord. In other, my lord, there is a vertical reservation, horizontal reservation, and the horizontal compartmental horizontal there is there. But in this case, my lord, the reservation for PWD is a horizontal, overall horizontal reservation, and within that reservation, the reservation of the benchmark disability.
Okay, before that, before we come to that horizontal or whatever,
Yes.
now the advertisement
Yes.
is of 2022.
Yes.
You have been selected.
Yes. And he also recommended.
Now, what is the scheme of selection? That after you are selected with your certificate, after you are selected, you will be put through another screening.
Yes.
And if you fail in the screening, you will not be appointed. But if your screening you pass, then you'll be appointed.
No, the scheme is, my lord, the scheme is the written examination and interview, my lord.
You go with your certificate, isn't it? At the initial stage.
Yes, I am applied on PWD quota.
Correct.
Yes,
Initial stage, you go with your certificate saying that I have this is my disability certificate.
yes,
And on the basis of interview, they select you.
yes.
After selection, you are sent for screening,
For, yes, yes.
medical screening.
Yes, which is not the scheme prescribed procedure of the selection procedure in this.
So show me the scheme. Where is that?
Yes, my lord.
Is it available in the advertisement?
Yes, even if, my lord, page 39, yes, your lordship can see, my lord. The selection process, my lord.
Yes. What is the process?
Serial number at 8, my lord.
8.
8, my lord, selection procedure.
Yes.
There shall be two parts of selection process, written test and interview, my lord.
Yes.
The select, then, my lord, subclause 3, my lord.
Hmm.
The selected candidate will have to bring all the original testimonials, certificate of proof of age, caste certificate in case reservation, education qualification certificate, economic education certificate, disability certificate in case of PWBD candidate, and declaration for verification at the time to be notified later among others and so on and so on. Then, my lord, the other condition is, my lord, at, my lord, serial number 4. The preparation of merit list and the appointment shall be made strictly in adherence to the relevant provisions of the Assam Direct Recruitment for Class 3 and Class 4 analogous post rules 2022, my lord.
So the problem is that when they have scrutinized your certificate, disability certificate, they did not accept it.
Yes, my lord.
You were put to a test.
Yes, my lord. And that is also not not permissible under the state law.
They put you to test and they found that you are only 30%.
Yes. But, my lord, I have been selected on merit, my lord. My lord, my lord, I have been selected on merit. And, my lord, and after that, what is the procedure remains, my lord? I will be appointed and I will be adjusted in the quota as in the category which I belong, my lord. I am a ST candidate, my lord. I have to adjust in the ST category, my lord. I got the marks, the cutoff marks above the cutoff marks of the ST candidate, my lord.
What is this, class 3 or class 4 category? Your appointment,
My lord.
your advertisement, the job you have applied for is what, class 3 or class 4?
Class 4, my lord. Class 4, okay, page 40, if your lordship see, my lord. The provisional result of a written test held on so and so. Page 40, my lord.
So at this stage, what can be done?
My lord,
We'll have to hear.
in similar case, my lord, in recently, my lord, the notice has been issued, my lord. And order, my lord, and any appointment.
Subject to outcome.
Any appointment made subject to the order passed in that, my lord, kindly see this order. Oh, দুটা গল এটা। Yes. Lots of writ petition are pending, my lord. My lord.
This is the same case.
Same case, lord.
Same case, two different orders.
My lord, no, same order, 2 copy has been given. Same, my lord.
Why giving me 2 copies?
My lord, sorry, my lord.
Your good name?
SK Roy, my lord.
Please write down, Lord Mr. SK Roy, Learned Counsel for the petitioner, who submits that the petitioner participated Where is the advertisement? Advertisement.
Provision, my lord, page 39, my lord, annex 3.
Participate in the recruitment process. For class 4 post under the PWD category. Since he has low vision and have 40% disability, which is duly certified by the certifying authority. So, although the petitioner was selected, he was subjected to further scrutiny, and wherein he was found to have only 30% disability. Now, as the petitioner has not been considered for appointment, he is before this court. Stop. The learned counsel for the petitioner submits that further scrutiny is not contemplated in the scheme of selection. And therefore, the petitioner has been illegally deprived of his appointment. Now, the learned counsel further submits that similar writ petitions have been filed by other similarly situated persons, and WPC number 5493 of 2024 being one such writ petition. Next para, in view of above, issue notice of motion returnable by 4 weeks. Miss R.
J. Gogoi.
J. Gogoi,
Respondent 3.
you are for the
Social Justice and Empowerment Department.
Miss J. Gogoi, learned standing counsel, Social Justice and Empowerment Department. Accepts notice on behalf of
Respondent 3.
which respondent? Ms. J. Gogoi, you are for which respondent?
Respondent number 3. Lords.
Only 3.
Yes.
Appears no accept notice on behalf of respondent number 3. Stop. Mr. CKS Borough, learned government advocate, Assam, accepts notice on behalf of respondent number 1 and 2.
7 and 8.
Mr. D. Upamania, learned Standing Counsel, Health Department accepts notice on behalf of respondent numbers 4, 7, and 8.
Lordship, I am appearing for 5. State level recruitment commission.
Mr.
B. Chaudhary.
B. Chaudhary. Learned Counsel appears for respondent number 5. And your good name? Mr. T. Thakuria, Learned Standing Counsel, Secondary Education Department, accepts notice on behalf of respondent number 6. Okay, anybody else left? Stop as such. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing for the respondents today. Stop. Having regard to the projection made by the petitioner, it is hereby provided that any appointment made during the pendency of the writ petition shall be subject to the outcome of this writ petition. This is the matter again after 4 weeks, along with WPC number 5493 of 2024.
So my submission was, my lord, the reassess is not permissible under the statute, my lord. They can, my lord, do everything, my lord. That should be as per the statute, my lord. That was my submission. And he has been meted out with the discrimination.
Okay, we'll hear you at the time of final argument. Item 17. I'll come back in 5 minutes.
Court, my lord, because that 90 days, the 90 days period, my lord, that suspension was not reviewed. Thereafter, my lord, on page 59, my lord will find the order of this honorable court. That is 6 months. That is in the month of April, my lord, at page 59. Under such circumstances, this court is of the considered view that since the rebuttal proceeding have already been initiated, the inquiry has been completed and the inquiry report has also been submitted. The disciplinary authority, competent authority should proceed to pass necessary orders pursuant to the report submitted by the inquiry officer. While passing such necessary orders, the departmental authority will also decide the question of the writ petitioner shall be continued to be under further suspension and pass necessary orders thereon. Any such order that is passed, copies thereof to be served to the writ petitioner. The entire exercise will be completed within a period of 2 weeks from the date of receipt of the certified copy of this order. My lord, at that point of time, my lord, the writ petition was closed because the respondent, from the respondent side, it has been stated that the proceeding has already been completed. The inquiry has been completed. That is in the month of April. But till that, my lord, my suspension has not been
revoked.
And my lord, I just pray before your lordship, my lord, that is a clear, my lord, violation of that provision, my lord. So within 90 days, if there is no review or no charge sheet filed, I have there is an indefeasible right, my lord, on part of the petitioner to be again restored back. Here, my lord, my suspension was on please on suspension 4/3 to 6/3/2023.
No, regarding charge sheet file, all that has now, everything has gone.
My lord, I just.
The order which you just read out,
Yes.
it says that the departmental proceeding has been initiated, inquiry completed.
Yes.
Inquiry report also submitted.
Yes.
So now you take a decision whether he should be placed under suspension.
Yes.
Further suspension or not.
Yes.
That decision has not been taken.
Yes, and that this order was in the month of April. So, my lord, now after that also, my lord, lordship will see on the next page on 60, there is another.
Yes, what is that?
That is, my lord, dated on 30/10, my lord. They have asked for, my lord, again to appear in the departmental proceeding for some cross examinations, etc., my lord. I have appeared and that is also done. My only thing is, my lord, let the departmental proceeding go on. I do not have any that part, my lord. But my suspension,
It has to be, my lord, restored within 90 days, on the 91 days, my lord. After the
91 days of what?
90 days, that from the date of suspension. Within that period, if the charge sheet is not filed, my lord, charges are not filed, because on 6/3, I have been suspended. 3/6, my lord, 90 days completed.
Okay.
Thereafter, only on 7/7, they have issued that, my lord, charge sheet. My lord will find.
But that aspect has already been taken into
Yes.
consideration by this court
Yes.
in the earlier round.
Yes. Now, my lord,
Now, why should we go back to that stage now again?
because, my lord, my right still exists, my lord. They have not taken up any decision, my lord, but my right is that.
Whatever it may be,
Yes.
rightly or wrongly, this
Yes.
court has already taken into consideration all these aspects and say that since now the inquiry report has been submitted, so respondents, you take a decision whether you want to place him under further suspension or not.
My lord, that order, in that particular order, my lord, 2 weeks time were given. Receive of certified copy of the order, entire exercise. So, my lord,
So what
that-
they have done now is some cross-examination as opportunity has been given to
Yes.
you.
My lord, can it be this way, my lord? Let them take a decision by another 2 weeks, my lord. Because,
How many orders is required from this court to
my
ask them
lord,
to
because
take a
they are
decision?
not complying with this order.
Then you should have filed appropriate application. You have not filed appropriate application saying that this order has not been complied with. Why should we repeat the order again and again?
My lord, because my humble submission is this, my lord. Since, my lord, 20 months I have been under suspension but law says otherwise. As my lord will kindly go through that departmental proceeding, my lord, manual 2.8. It says, my lord, charges and the statement of.
Same book,
Yes, same book, my lord.
page number.
Page number would be 467. Two, my lord, 218, 218 and subclause 2. Charges and the statement of allegation should be served within 3 months from the date of suspension, failing which the government servant concert should be reinstated. Law is absolutely clear, my lord, on that. And they have served this, my lord, statement of allegation after 90 days. So at this stage, my lord, I may be reinstated and let the departmental proceeding go on, my lord.
Yes.
Regarding this restatement, my lord, that this honorable court has already passed order. So prisoner should have come with appropriate.
You want one more order?
No, my lord.
Then
So, my lord.
your court has already passed the order. Why are you not doing
Regarding,
anything?
my lord, kindly see the page 61, my lord.
61.
Yes, my lord.
Yes.
Relevant person, my lord. It has been seen from the reply of the delinquent officer dated 1/12/2023 that delinquent officer has stated that he was not provided with opportunity to cross-examine the complainant. And another witness and has also which is clearly violation of principle of natural justice and necessity carefully. And he has also stated that he was not also provided with opportunity to adduce his evidence or witnesses. As such, my decision has been taken, and now he's been asked to appear before that officer.
When?
My lord, we have appeared.
That my lord,
when?
Phase 62, my lord.
62, I could not appear, my lord. Thereafter on 30, 30/11, I appeared, my lord. But this is another aspect of the matter, my lord, regarding the departmental proceeding, because we have filed the written statement there.
You're playing instructions, Mr.
Yeah.
Counsel.
My lord, another aspect, my lord. It says, my lord, the repression shall be continued to be under suspension and pass necessary speaking orders thereon. Regarding my suspension, my lord, no decision has been taken. Departmental proceeding is another thing, my lord.
Please write.
Yes.
Heard, Mr.
T.H. Hazarika.
T.H. Hazarika, learned counsel for the petitioner, who submits that this is the second time the petition is before this court. Stop. The earlier writ petition being WPC number 6344/2023 was disposed of by order dated 22/4/2024, wherein it was observed that in view of the submission of the inquiry report by the inquiry officer, the disciplinary authority / competent authority should proceed to pass necessary orders pursuant to the submission of the inquiry report, and at the same time take a decision as to whether the petitioner should be continued to be placed under suspension by passing a speaking order. Stop. The learned counsel for the petitioner submits that despite the said direction, no speaking order has been passed by the disciplinary authority, and the petitioner is still under suspension. Which in fact is in gross violation of clause 2.1.8 bracket small Roman 2 of the
manual, my lord, of disciplinary proceeding.
Assam Services Manual in respect of departmental proceedings. Next para, the learned counsel further submits that the petitioner was allowed to cross-examine. Which witness?
My lord, informant.
The informant, which otherwise has also been completed on 30/11/2024.
Correct. Right.
Stop. He therefore submits that the respondents should be directed to reinstate the petitioner pending finalization of the departmental proceeding. Next para, issue notice of motion returnable by what about the interim? Returnable by 3 weeks.
Interim period is
Mr. G.
considered
Pegu,
as
learned State
return
Council,
by-
accepts notice on behalf of all the respondents,
No, my lord.
on behalf of
Respondent number 1, 2, 3, and 5, my lord.
respondent numbers 1, 2, 3, and 5. Mr. D. Bora, learned counsel, appears for respondent number 4. Who else is rep?
No.
Notice is therefore complete upon the respondents. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing for the respondents today, within 2 days. Next para, also issue notice on the interim prayer. You have an interim prayer.
Yes, my lord, I have interim prayer.
Mr. G. Pegu, learned counsel, shall obtain instructions by the next date. This again also and so.
My lord, can I pray for an early date, my lord, because already 20 months, my lord, under suspension. 2 weeks, my lord.
Mr. Pegu, when can you? do this?
16.
16. 12th.
12.
12th.
I did 2 only.
12th is next week, Thursday.
16.
16.
Obliged.
Obliged, my lord.
But in similar matter is pending, my lord, and fixed on 18/12.
Lordship, let it be on 9th. Notice may be issued, let it be fixed on 9th, Lordship, because on 18 number of matters are there. Because I have to brought every records, Lordship. That's why on 9th. Lordship. Let it be on 9th. Notice may be issued and fixed on 9th.
Candidature has been rejected on the medical ground.
What is the matter?
Matter, my lord, applied for constable, my lord, in pursuance of the advertised by staff selection commission, my lord. He has passed all the segments, my lord, and finally, my lord, candidates are rejected on the ground of medical, my lord, medical ground, my lord. That is, my lord, one aspect, defective distant vision, and second, my lord, irritant contact dermatitis. Some, my lord,
What is that second one?
irritant contact dermatitis.
Where is that?
Skin infection over the lower.
Skin infection.
Page.
Test 64, my lord.
Defective one, distinct. Irritant contact dermatitis. This is not curable.
My lord, thereafter, my lord,
It may be curable, but he has the deformity, Lordship, because in the CAP, it is not acceptable.
So what is this test?
Lordship, they have taken the opinion of the diagnosis of a dermatologist. After taking that.
No, that is not what I'm asking.
Lordship.
See, you run a selection process.
Yes.
Screening, everything.
Yes.
After selecting a person, again you put him to another test.
No, this is the medical test.
Medical test.
Yes, which is.
Medical test is not, is it not done at the initial stage?
No.
This is the problem, you see.
No.
You should advise your clients.
Lordship, this is the.
Whatever
procedure.
medical test you want to do it immediately.
Yes.
Thereafter, whatever merit you want to do merit. Then if
Lordship,
you pass.
what happened, Lordship, here written test, then PST, PET, thereafter medical test, Lordship.
Whatever police verification, all this
That
can be done later on.
Later on.
But medical, you do the medical at the initial stage.
It is in the initial stage, Lordship.
Why give them false hope?
No, Lordship, this is the initial stage. After Lordship,
computer-based
written thereafter PST, PET, thereafter medical, Lordship. For physical test, then the review medical tests are done, Lordship.
Heard Mr. K.R. Patgiri, learned counsel for the petitioner, who submits that the petitioner participate in the recruitment process for constable (GD) in the CAPFS,
NIA,
NIA and SSF and Rifleman GD in Assam Rifles examination 2024. Advertised on 24/11/2023. We'll get in page 2, huh? Post title, the details. Stop. Although the petitioner got selected in the selection process, but he has been found to be not eligible in the medical test. On account of defective distant vision 6/12 RTI and irritant contact dermatitis. Page 64. You'll get it there. In view of above, issue notice of motion returnable by
9th of January. 9th of January.
9th of January 2024. Mr. S.S. Roy,
Lordship.
Lanet CGC accepts notice on behalf of all the respondents. Petitions to serve requisite extra copies of the read petition within 2 days. This is the matter along with WPC number.
No, Lordship. This matter is fixed on 18. So this will come on 9th.
I see.
All right. All right.
Miller.
Here in this case, my lord, petitioner is challenging the OM dated 18/9/2024, my lord.
Page?
Page, my lord,
You're challenging
35.
OM,
35,
35.
yes.
What is this OM about?
OM above means, my lord, up to 2013, my lord. But before 2013, my lord, nobody is considered as a compassionate appointment, my lord. And in this regard, my lord, similar case is pending, my lord. WPC 5067 of the 2024, my lord.
Mr. Martin, be clear, what are you challenging?
Yes, page 35,
OM.
yes.
What is this? What is it about?
About, my lord,
Compassionate appointment.
compassionate appointment. Already DLC approved, my lord, and sent to the state for placing the matter before the state SLC, my lord. But in the, when the, going to place the matter, my lord, in the meantime, my lord, 18/9/2024, my lord, issued the OM, my lord, with retrospective effect, my lord. So whereas, my lord, our case is, my lord, already DLC recommended our names, my lord.
Where is the offending clause according to you?
My lord.
Offending clause in OM?
Yes.
Which one?
7.5.
Please read.
Six, my lord, page in view of
So what can be done? Notice will go, that's all.
yes, my lord. A similar case is already issued notice, my lord.
Mr. A. Martin.
Your Lordship, I am appearing on behalf of the respondent numbers 1, 3, and 6. Here, this particular writ petition is not maintainable simply on the ground of non-joinder parties.
Who?
Personal department. He has not made a personal department a party he has challenged.
Who
the
has
OM.
issued this notification?
OM has been issued by personal department has not made a party.
Mr. Martin, how could you forget all these things? Basic too. You want to amend?
Lord, I may be allowed to retain handwritten, my lord.
No. If we allow you, we have to allow everybody. Everybody will start writing by hand.
My lord, I may be allowed to file amendment question.
As paid for by. Should I issue notice otherwise?
Yes, issue notice, my lord.
Issuing notice will not do. Let it be kept in a motion stage itself. Let him file a IA for.
As paid for by Mr. A. Martin. Impleadment of the personal department is allowed, which otherwise should be done by way of filing an application. List again after
And next week.
a week. You file tomorrow, we'll list it then?
Yes, tomorrow I can file.
When?
Friday means.
List on Friday. Give the date.
Right.
Please rewrite again. Cancel the order. Rewrite. As paid for by Mr. A. Martin. List the matter again on Friday, the date. In the meantime, the petitioner may file an application to implead the personnel bracket B department, government of Assam.
Similar 23 Sam, my lord.
If so advised. 20 and 23 same.
23, my lord.
This item was what?
23.
This present item was 19.
19.
20. 20 and 23 similar order.
Oh, less.
Read please, your lordship.
Yes.
Hello, in this case, petitioner is praying for disability pension as he was discharged from service on medical ground, but his prayer was rejected. But similarly situated persons are getting, my lord. I have annexed, kindly see. Annexure 4, page 28. And annexure 5, page 29. And similar order, I have annexed, my lord, last page annexure, page 45. I am entitled, but they have said that 10-year service is necessary. But for disability pension, no such requirement is necessary, my lord. So, my lord, my prayer before your lordship at this place notice may be issued.
You were discharged on medical ground.
Yes, ma'am.
Have you enclosed the
Hello?
discharge order?
My lord, discharge order they have not given to me. I have only annexed the discharge book, my lord. That is also not legible. I have given the type relevant portion annexed.
No, you have to make out your case. You have to make out your case.
My lord, I have annexed the discharge book, my lord, annexure 1. And my lord, kindly see rejection order, my lord. Annexure 7, my lord.
No, question, don't, see, my question was, where is your discharge order?
Annexure 1, my
You
lord.
say discharge order is not there. Discharge book is there. Where's discharge book?
Yes, my lord. Annexure 1, my lord. I have made the relevant portion type copy.
Next year one is not legible.
Yes, my lord. Only relevant portion I have that. Kindly see page 16, my lord.
Page 16.
Yes, annexure 1.
Yes.
Last portion, my lord, reason of discharge on medical ground, my lord. After, my lord, rigorous, my lord, examination, I was selected and appointed, and during training, my lord, I got some injury or developed a disease, my lord. Suddenly they have discharged me. That is okay, my lord, but I am
And suddenly you have come after how many years?
my lord,
Discharge in 1992.
maybe, my lord, because they have not given to him kindly.
Suddenly you have come after 32 years.
What
is this?
My lord, pension, my lord, pension, there is no delay, my lord, because it is them, my lord, they have to give me pension, my lord. I have submitted many representation, my lord. Lastly, my lord, kindly see, they have rejected annexure 7, my lord.
Annexure 7,
Yes,
where is that?
kindly see page 34. They have given, my lord, reply to my legal notice. Paragraph 3, my lord. May I read, my lord? Annexure 7, page 34.
Yes, read.
First of all, my lord, Para 2, legal notice has been examined at this directorate and it is revealed that your client so-and-so was enrolled in Assam Rifle on 11 December 1990 and discharged from service on medical ground on 31 January 1992. He rendered 1 year, 1 month, 20 days service with Assam Rifle at the time of discharge from service. It is brought to your notice that pension of Assam Rifle is governed by the Central Service Pension Rule 1972. As per Rule 49(2) of CCS Pension Rule, minimum 10 years qualifying service was mandatory requirement for grant of invalid pension.
So,
My lord, that will not be applicable for me, my lord, because
why not? Why not?
because I am paying for disability pension. Next line, my lord, kindly see.
Disability pension under what provision?
CCS Extraordinary Pension Rule, Madam 1913. Kindly see furthermore, in terms of CCS Extraordinary Pension Rule 1939, to be eligible for grant of disability pension, an individual should be medically boarded out from service with not less than 60% disability. Disability should be attributed to or aggravated by service condition, and diagnosis should be specified in Schedule 1 or Schedule A of Central Service Pension Rule 1939. In the instant case, disablement of your client is neither specified in Schedule nor in Schedule A, CCS Extraordinary Pension Rule 1939. Hence, it is not entitled for disability pension. But my lord, kindly see page 45, my lord, last page. Exactly similar, my lord, order allowed by this honorable court, my lord.
45.
Yes, last page. para 20, my lord. In view of the aforesaid reason and discussion, it is held that petitioner is entitled to disability pension and the impugned decision dated Iman is illegal and arbitrary. Accordingly, respondents, more particular respondents 2 and 3 are directed to grant disability pension to the petitioner from the date of discharge on medical ground. Such pension be paid within a period of 6 months from the date of furnishing a certified copy of the order. This is similar, my lord, and they are getting, my lord. Almost all persons who are disabled, someone is getting from 1982 also. I have clear instruction, my lord. So on
No.
this,
How can you draw a similarity with that case? What is similar with that case and your case? What is this? What are the similarities?
similarity, my lord, he is also disabled, my lord. And then, my lord, kindly starts from page 36. Similar order, my lord.
How you have been invalid? What was the invalidity in your case?
My lord, in my case, during training, my lord, kindly see. And it's page 6, para 5, my lord.
No, you just tell me like that. What has happened to you?
During my lord training, my lord, I developed a disease, my lord.
What disease?
Kindly see page 5, dubbing Domini syndrome. He was admitted in hospital because of this, my lord, and suddenly I became normal, my lord, they discharged me.
Where? Page?
Page 6, my lord.
Page 6.
Para 5 and 6, my lord.
Dubbin Jomani syndrome. What is this?
This is a disease, my lord.
Huh?
Disease,
What
my
kind of
lord.
disease?
During training, he was suffering from disease. He was admitted in Assam Rifle Hospital. Later on, he was referred to Hospital Kolkata for further treatment.
So where are those letters, documents?
My lord, they have not given me, my lord. That is my problem, my lord. Suddenly, my lord, they discharged me. After treatment, I became normal, my lord. I want to continue my training period. But they have not, my lord, given that chance to me. And suddenly discharge order was issued. Even they have not given me discharge order also. Only discharge book, my lord, I have collected. In the impugned order, my lord, where they have rejected my claim, it is all are written in the rejection or reply to my legal notice. Annexure 7, my lord, page. Annexure 7, my lord, they have given that I am not entitled, but I am entitled by the, because of this.
Who's for the government?
There are so many orders, my lord, other order also, where my lord, honorable court has allowed, my lord. I have got other similar orders also.
There has to be a very good reason for that.
No, my lord, disease. They are also
Simply by producing one kind of similar order will not give you,
no,
you
my
cannot
lord,
get such kind of benefits.
suffering from disease during training. Can you see?
Maybe.
Or my lord, can you see the rule also? Invalid.
We're not seeing anything right now. All right. You have not given any proper documents also. You seem they are not giving. What do you mean they are not giving? If they're not giving, how will you file your case?
My lord, in the impugned order, they have stated the reason why they have. Annexure 7, my lord. Annexure 7, my lord, they have said that I am not, but that is not, my lord, correctly, they have not.
Please write down. Your good name?
Yes.
Third, Miss S. Bora, learned counsel for the petitioner, who submits that the petitioner, having not been given invalid pension, is before this court. So it is seen that the petitioner has come to this court after having been discharged on medical grounds as far back as on 31/1/1992. So it is further seen that the petitioner had only rendered about 1 year, 1 month, and 20 days of service. Now, it is therefore seen that the petition has come to this court after a considerable delay. Now, although claim for pension claim for what is called invalid pension may not be barred by such may not be may be claimed even belatedly. No, you don't write that. Okay. Read. Full stop. However, noticing that the respondents have given a response to the legal notice served by the petitioner on 26/5/2024. And at the same time, having regard to the claim made by the petitioner that in other similar, in respect of other similar personnel, invalid pension has been granted. The claim of the petitioner may be examined. In view of above, issue notice of motion returnable by 4 weeks.
In this case, always matter not be allotted to me. I can take the notice lordship on behalf of DSGI in the matter, being CSC lordship, on behalf of Assam Rifles. So notice may not be, sir. I can take the notice at this stage lordship. I may inform the matter to the council who has been allotted with the matter. So,
Notice may not be issued.
notice may not be, notice may be, sir, but I may be, my name may be entered in the on behalf of the respondents lordship.
Okay, your good name?
CKS Boro.
Mr. CKS Boro. Your CGC?
Yes, lordship.
Mr. CKS Boro, a learned CGC, accepts notice on behalf of all the respondents. Petitioner to serve requisite copies of the petition to him within 2 days. This again after 4 weeks. We examined this aspect. Yeah, have you heard what he said?
Yes, sir. That non-payment of that valid pension program. And the particular disease that he has been under.
32 years. After 32 years.
And which he has contracted during the time of training.
But the respondents have given a reply saying that he may not be eligible because of these decisions. We'll see. Anyway.
May I please, your lordship? The petitioner herein is the husband of late Rekharani Kotagi, yes, your lordship, who was a lecturer at Assam Satriya Sangeet Mahavidyalaya, Rajawari, Jorhat. She was initially appointed in the year 1999 by the committee of the college, Annexure B, page 13.
What is NPS?
New pension scheme.
What you've written NPS scheme.
Typographical.
That means NPS scheme.
Typographical.
Double scheme. Okay, so you're praying for pension of your wife.
Yes, your lordship.
Family pension. She's expired.
Yes, your lordship. That certificate is at page number.
Will issue notice.
Yes, sir.
Heart, Mr.
M.R. Sodial.
M.R.
Sodial. S-O-D-I-A-L.
M.R. Sodial. Yes. Learned counsel for the petitioner who submits that the wife of the petitioner having served as a lecturer in Sanskrit in Assam Satriya Sangeet Mahavidyalaya
Rajawari Jorhat.
Rajawari Jorhat. First title in over. Is entitled to receive pension. However, as she expired when?
28/3/22.
28/3/2022. The petitioner as husband of the late lecturer is entitled to receive family pension under the new pension scheme 2005. Next matter, in view of above, issue notice returnable by 4 weeks. Anybody? Mr. P. Naik, learned. Sorry, 1 and 5. P. Naik, learned, Standing Council Finance Department, appears for respondent numbers 2 and 3. And accepts notice. Mr. C.K. Boro, learned, GSR, accepts notice on behalf of respondent number 1 and 4. And Mr. R.K. Talukdar accepts notice on behalf of respondent numbers 5 only. Respondent 5. Petitioner to serve requisite extra copies of the writ petition to the learned counsels appearing today within 2 days. Petitioner shall also take steps for service of notice upon respondent number 6 by registered post with ADD within 3 weeks.
Deeply obliged.
26.
Lordship, this is a case of departmental proceeding
Hmm.
against the predecessor in interest of the petitioners. And in the departmental proceedings, petitioner in interest of the petitioners have been removed from service, and the impugned order is in page number 111. And we have silenced the departmental proceedings, impugned order, and also the consequential actions for the grounds. Number 1, Lordship, on the same facts, the respondent authorities had filed an FIR of forgery, cheating, and criminal breach of trust on 24/4/2018, which is in page number 57.
What is the outcome?
Final report has been given. Final report has been given.
Where is that page number?
Page number 105. May I read?
Okay, I've read it. Now, who is the petitioner?
Rita Sharma and 2 others.
What
We are the
was-
legal heirs of Hogan Sharma.
Legal heirs.
Yes.
Legal heirs means their children,
Wife and children.
wife and children. You are challenging the removal from service.
Yes. On the same facts, the searches has been framed as well as the criminal case has been filed. And in the criminal
Can you
case,
show me where is the charge? In
Sir,
in
yes.
DP.
Lordship,
Charge in DP.
searches in page number 63.
Who's for the bank?
Appear for the
Will
bank.
issue notice?
Lordship, I'll take notice. We'll have to file a reply in this.
You're Mr. D. Chaudhary.
No, I am Mr. R.K. Sharma.
Heard Mr. R.K. Sharma, learned counsel for the petitioner, who submits that the petitioners are the wife and what, daughter, son?
One son, one daughter.
Rita Sharma is the wife.
Rita Sharma is the wife.
Anku Pratim
Anku
is
Pratim
the
Sharma
son.
is the son. And British Sharma is the daughter.
Oh, 3 of them. Wife, son, and daughter of late Hogan Sharma. And by filing this writ petition, they have challenged the order dated 31/10/2019, by which he was removed from service. Stop the learned counsel submits that departmental proceeding was initiated against the late employee. And at the same time, a criminal investigation was also set in motion under the one and same charge. Full stop. The criminal investigation ended in a final report. Whereas the petition, the late employee was removed from service.
Lordship,
In the departmental proceeding drawn against him. Yes.
departmental proceeding was conducted after the retirement also, taking it to be deemed in service. So the order of removal was passed on 31/10/2019, whereas with effect from the effect has been given from the date of retirement 36/2018. That is one point. Yes, sir.
So the learned counsel further submits that the departmental proceeding continued even after the employee reached the age of superannuation. And the impugn removal order has been passed with retrospective effect from 36/2018,
Lordship,
which is bad in law.
Lordship, we have an interim prayer also in page number 27.
What is that?
Lordship, it has since been more than 6 years. And we have not been given the provident fund, my own deposit. We have not been given group saving liens insurance scheme, which is my own deposit.
Well, on that, and if I may interrupt my learned friend, Lordship may kindly direct the bank to consider that part of the eligible service benefit. That I have
Next
no
para,
objection.
in view of above, issue notice of motion returnable by 4 weeks. Mr.
A. Ganguly,
A. Ganguly, learned standing counsel,
Assam Gramin Vikas.
Assam Gramin Vikas Bank accepts notice on behalf of all the respondents.
all the respondents.
Petitioner to serve requisite extra copies of the writ petition. Next para, it is also submitted by the learned counsel for the petitioner that the gratuity entitled to the late employee, the provident fund and group saving linked insurance scheme has not been paid to the petitioners till date. Although they are the legal heirs of the late employee. Stop the respondents. No, stop the considering the same. The respondents are the respondents are directed to examine the same and disburse the amount which is due to the late employee to the petitioners.
Lordship,
Only one aspect of the matter. Lordship will kindly add, as per the service regulations. That part Lordship will add to the end. Because otherwise, it seems like a mandatory direction to release everything.
as per three areas.
My learned friend
As
can
per the
argue it.
relevant admissible rules.
Yes, that is that part.
Lordship, can a definite time frame be given because of already it has crossed more than 6 years?
Yes, 45 days from today, madam.
Within a period of 45 days
45
from
days,
today.
45.
Deeply obliged.
See, with the corporation, this is happening. Otherwise,
Because in a fair case, why should?
yes, correct.
CD, it becomes chief medical officer. So it's in the same rank. Cadre is same.
So what is this notification about?
Well, this notification in September of 23, I come to that cadre. And normally, I wait for the gradation list because now I become eligible to be promoted to the next level of joint director.
So this is a promotion order,
Yes,
page 84.
yes. And the page 89 is the gradation list.
You're at serial number?
Well, before that, I just want to make a submission. The Lordship knows that we, the reserve, are entitled to accelerated promotion and consequential seniority. For 20 years, we have been getting it, and there was no dispute. In the gradation list of 11 December 23, I was all along on the top of the list, either on 6th or 16th. Suddenly, I come to know the operative part is at page 91. I come down at serial 27, and I see two very important things. Your Lordship, as page 91, your Lordship will see at serial 27, Torun Deuri is the person, the petitioner. Your Lordship will see the columns now. Caste or reserve, STP, date of birth, same above, date of entry into service, 22/12/88. This is important, Lordship. Date of promotion as in the cadre or equivalent rank, 23/9/2022. And I complete, at present I'm completed 2 years. My Lord, your Lordship will find that the date of entry was something which was very alien, because as soon as the date of entry comes in, the question of cadre goes and the question of groups come in. Your Lordship will find that when this order was passed, gradation, I give my representation, and then your Lordship will find that they prepare a final gradation list, which is at page 101. It's on October 2024, in continuation of the draft gradation list published by such and such, in respect of the medical officers in the rank of CM and HDO or its equivalent rank, and after examining the petition so received and discussed, the Governor of Assam is pleased to notify the final gradation list in the rank of such and such or his equivalent rank. This stands as the final gradation list of officers in the rank of CM or its equivalent rank of 2024. My Lord, your Lordship will find that in the meantime, the Assam government comes up with an OM of 2023, which is at page 127. Mala, the sum and substance of this OM is that for the first time in Assam, the services are broken up into groups, and they make it into 3-4 categories of groups. Your Lordship, I'll take your Lordship to page 28, 128. Well, before I read, then I'll give an explanation. Your Lordship will come to paragraph clause 4.
Yes.
In case of promotion in Group A service, the quantum of reservation for SC, STP, and STH in promotion shall be as per the stipulated percentage of reservation available for these categories. However, SC or STPH in Group A under accelerated promotion by virtue of rule of reservation shall not be entitled to consequential seniority. Unheard of. The application of general catch-up rule will allow eligible officers who were senior in the merit list at the entry level in Group A services to regain their seniority in the promotional post. Once they are promoted to the same cadre as an officer of reserve category, provided the officer of the reserve category have got his promotion ahead of an officer senior to him in the merit list by way of accelerated promotion on account of reservation in promotion in a particular cadre, seniority of government officers at Group A shall be revised as per this principle. Further, an officer promoted from B to A will also regain his seniority in Group A service on promotion vis-a-vis his compatriots in the Group B service, provided that the officers were senior to the reserve category officer in the particular Group B cadre prior to the promotion of the reserve officer into the Group A. Seniority of such B government servant promoted to A shall be revised accordingly. If on an occasion arise during the promotion process in A, service in which stipulated percentage in respect of reserve candidate is met in the next promotional cadre, but in the zone of consideration, there are several numbers of reserve category who on merit are entitled to promotion, their case shall be considered for promotion on merit if such candidate have not made into the zone by way of any accelerated promotion RDR by the virtue of rule of reservation. Then your lordship will come to B, which is not applicable to B. For the junior officer, they say that you will be given the benefit of consequential seniority as you move up. Means we will be given the seniority at the lower level as we go up. Out all of a sudden, this clause will operate. Now, what has happened? By this OM, my lord, the gradation list were being made and a new column comes up, which is the date of entry into service of APSC. But my promotions in each cadre, seniority will be assigned what has to do with my initial entry about 30 years back, 27 years back, as regards my APSC list. But now this chaos which has been made, well, I come down to 42. Now, my information is that there are certain vacancies which now will be filled up. And I have raised a very important issue that this gradation list is not only in violation of the rules of the health department, but also in violation, in flagrant violation of the Supreme Court's latest judgment in Journal, where Supreme Court has categorically said, without cadre, you cannot make groups. In fact, the group-wise, if you bring in, then you bring the entire service into the system and entire service has got no relevance. And that has been deprecated by the Supreme Court in a 3-member judgment of Jarnail Singh. Because this confusion which was arising has been now finally settled. So what I pray, Lordship, your Lordship will issue notice, the Lordship will need to examine this matter. But the gradation list will have to be examined because our career is at stake for no fault of us. You bring an alien concept of date of entry of APSC. Well, this is unheard of. And the rule says that the gradation has to be cadre-wise. Well, I understand that with the OM, you want to give benefit to some, but you cannot flout the constitutional principles and the rules. So what I pray, Lordship, at this, Lordship will issue notice, and since the vacancies will be filled up, well, without the leave of the court, Lordship, I'll require Lordship to examine this matter. I have raised a very important issue, which is a prima facie violation of the rules and the Supreme Court orders. I need not go through the judgment and read the judgment, but it's very clear. Length of service cannot be claimed.
Is it something to do with the interpretation?
Malam?
Is it something to do with the interpretation?
What interpretation, Malam?
The office memorandum which you just challenged.
The interpretation and the office memorandum must be in compliance of the rules.
So why I'm saying this is because the very judgment which you are relying upon,
Yes.
Journal C and all that,
Yes.
that has also been referred to in the impugned office memorandum.
Yes. But in fact,
They say that they're looking into that also.
as an abundant caution, in my PR, in my petition, I have also challenged the OM because I'm ready for the full-fledged hearing. I've brought grounds of challenge of the OM. I did not challenge the gradation list per se. The Lordship will see my order. I have challenged the particular clause by which we are sought to be deprived. And this is a very important issue because ultimately the court will have to give an interpretation in. And there was a series of litigation also around these issues, but the Journal Singh was not there. So since this matter relates to an issue where we are seeking a judicial review of a interpretation given to the government and prima facie, I can show that prima facie is in direct violation of the cadre, because ultimately if the cadre is not taken and the date of entry into the APSC is taken, can we the gradation list be proper?
Date of entry into the
In the cadre, I entered service, that list is being taken. The purpose is very simple. They want through the back door, they want to bring the catch-up principle. Because once the catch-up principle is brought in, the reserve general gets a jump over. which has now been negated by the 85th Amendment. And this has been happening in all the departments. Malad, this is just a beginning, tip of the iceberg. In fact, all officers of the reserve are going down. Malad, I go down for a purpose. I cannot go down on concepts which does not have any semblance of legality. That's my case. So I'll call upon your lordship to at least examine the matter. And since no promotions are there, at least your lordship will pass an interim order that without the leave of the court, and we are ready to face the hearing also. But if the matter is thrashed up, we will be the happiest because at least the law will be set up. We cannot lose our career forward. All along, 25 years I go up with no problem. Now suddenly an OM comes and brings me down on a criteria which is not permissible under the law.
So you're basically agree with this OM
The OM, and the gradation list, impugned gradation list.
gradation list is at page?
The final gradation list is person
Page 101.
101. I come down to 43. And your lordship will find a very important point I like to say. The lordship will find that 1, 2, 3. On the 6th column, there are 7 columns.
No, just a minute. 101, you say?
Yes. The final gradation list.
101.
Dated 18/1/3. Your lordship will find that.
Where's the date? It's 2310. Isn't it?
18/1.
18/1?
No. This one.
101 is 2310. Are we looking at the same?
Gradation list is 103.
No,
102 and 3.
that is the list. The forwarding notification is 101.
Yes, my lord.
Date is there.
Yes, my lord. It is
Date is
October 24.
23rd.
October it is given.
So
23rd. Yes.
23rd.
The third.
Under the below the signature or whatever.
Yes. And they mention also this stands as the final gradation list.
This gradation is prepared in terms of the notification.
Yes, my lord. In
Yes, my
terms
lord.
of the notification dated 18/1/2023.
I see.
And your lordship will find that in the 6th column, they bring 2 columns. 4 column is a new concept, a date of entry in APSC list, and the 6th column is important, date of promotion in that cadre. In fact, your lordship will find that persons who come to the cadre later on, they go above me. I should have remained between 1 and 6.
You are agreed with the date of entry into
Yes,
service
because ultimately the
as per
date of-
APSC.
Yes,
And
APSC is got no relevance because the rule says cadre wise.
any other column in this which you are aggrieved of?
Yes, the 2nd column,
Which one?
the 6th column, date of promotion.
As CM and HO.
Yes, the lordship will find that.
Why is that?
My lord, your lordship will find that from serial 14 downwards till 41, I am at 42. These are people who go to the cadre after me and they are brought above. That is the grievance because they were all a long junior to me because I was entitled to the accelerated thing. And these people have, I come to the cadre 22. I think till 22, it is okay. But from 14, 15 onwards, persons below me, and what has happened now, the qualifying service to be the joint director is 2 years of qualifying service in the rank of chief medical officer. I've completed it, and many officers who have superseded me have completed 1 year. Now, once the promotion is there, there'll be a chaos now. The rules of second rule, rule 11 also will be violated because they don't have the qualifying service. I have the qualifying service. So I'm aggrieved by column 4 and column 6. Because if column 6 was complied with cadre wise, I would have been at top. By 1 to 14, I would have. Now I'm down below 42. And those officers who came to the cadre later, they go up. That's my case. And now I'm pretty sure for the simple reason, it's not a question of interest, it's a question of the finality by the Supreme Court that if you take the entire service like the APSC, that gives a incorrect picture. It has to be cadre wise, not group wise. And the government of Assam has gone by the group wise.
Yes, Mr. Bora.
My lord, notice may be issued, my lord, but no stay order may be granted because, my lord, the final gradation list has been published in terms of a draft gradation list. Your lordship will find a draft gradation list at page 96, my lord. Draft gradation list was published, provisional gradation list was published on 26/9/2024. And this was published in terms of the same office memorandum dated 18/1/2023. And while publishing the provisional gradation list, my lord, claim or objection from the in respect of the provisional gradation list was called for, but the petitioner did not make any claim or objection, my lord. And subsequently, the final gradation list has been published. So, my lord, when he did not submit any claim or objection in terms of the provisional gradation list, my lord. So at this stage, my lord, stay order may not be granted because that the provisional gradation list was also prepared in terms of the office memorandum dated 18/1/2023, my lord.
My lord, we have given our objection, which is at page 131. My lord, we gave our objection. It was not totally ignored. So where will I go? I'll have to come to the court only. Lordship will find at 131, I give my objection regarding the provisional gradation list.
My lord, this objection doesn't contain any receipt or, my lord, it was not filed.
Let us not go into whether they receive it or not. No, that will be a clerical thing. Well, we are on the substantive question of legality or illegality. Your lordship, I am praying for the interim order for the simple reason they will go ahead with this, and ultimately I'll be totally prejudiced. And it is not that the promotion we are stalling. We are courts do pass orders that without leave of the court they will not proceed.
No, my lord.
They can process whatever they do. Because since I have raised an issue of judicial review, I'll call upon your lordship to at least examine this matter. This is a very important matter which affects our career. And we have come at the right moment.
Mr. Bora, you're saying that as per the office memorandum, it is being prepared.
Yes, my lord.
Correct.
Yes.
But they have challenged the office memorandum also.
They have challenged, my
They have
lord.
questioned the office memorandum also.
The office memorandum was of the year 2023, my lord.
Correct.
They have challenged it now, my lord. So on the basis, if they have challenged, my lord, but stay order on that basis cannot be granted, my lord. And more particularly when they have not filed any objection or regarding the provisional gradation list, my lord.
Well, if I am to read again, then I think
131, page 131 is the objection.
Page 131, my lord, it is not received or received by anybody, my lord. And secondly, my lord, page 131, my lord.
Well, he is a senior officer. He won't go and throw it in the office. Well, he'll go and place it. Well, he makes a submission that receive and all.
Cannot be. My lord, interim order may be considered after service of notice on the private respondents also, my lord, because they are private respondents, my lord, who are above the petitioners, my lord. They will be the affected persons, my lord. So, my lord, at this stage, my lord, and secondly, my lord, or your lordship may take up the matter day after tomorrow. I will confirm, my lord, whether this objection was received or not, my lord, whether it has been filed or not, my lord. Because from the perusal of the page 131, it doesn't indicates that it has been filed properly or it has been received by the departmental authority, my lord. There is no seal or any docket number or nothing is there, my lord.
What is the statement otherwise which is being made?
In the statement also, my lord, there is no such. Page 30, para 37, page 43, my lord. There is no
In
statement
fact, we have
to
also-
that effect that whether it has been received or not, my lord.
My lord, we had also brought in a very important issue of special drive, which is a statutory requirement in terms of 16(4)(b) of the constitution. That has also not been done by the government. My lord, let us forget about this. We have the larger issue of whether special drive needs to be done or not, because the backlog vacancies were never filled up. And the lordship knows the backlog vacancy, the 50% breach can be done.
Under
is 16(4).
regarding all these issues, notice maybe.
That is the reason we want an examination.
Does not inform us.
Okay, please write, heard Mr. D.K. Das, learned counsel for the petitioner, who submits that being aggrieved with the final gradation list of Chief Medical and Health Officer and its equivalent rank as on October 2024, issued by notification dated 23/10/2024, bracket annexure J, comma, the petitioner has filed the instant writ petition. To stop, the learned counsel submits that the petitioner is also aggrieved with the office memorandum dated 12/6/19, I'm sorry, office memorandum dated 18/1/2023, bracket annexure P. By which it has been provided that the date of entry into service as per APSC is to be reckoned for the purpose of fixation of gradation. To stop, the learned counsel therefore submits that pending final consideration of the writ petition, the impugned final gradation list as well as the application of the office memorandum dated 18/1/2023 may be stayed. Next, para in view of above, issue notice of motion returnable by 4 weeks. Mr. BP or DP?
DP, my lord.
Mr. DP Bora, learned standing counsel, health.
I'm appearing for respondent number 3, 5, 6, and 7, my lord.
Appears for and accepts notice on behalf of respondent numbers 3,
5,
5,
6, and 7.
6, and 7.
1, 2, and 3.
Mr. CKS Boro, learned state council accepts notice on behalf of respondent numbers
1, 2,
1,
4.
2, and 4. Stop. As such, notice is complete upon the said respondents. Petitioner shall furnish requisite extra copies of the writ petition to the learned counsels appearing today. Stop. In respect of the remaining private respondents.
My lord, here I'll just make a submission. We couldn't get the address because we can't go for RTA also, they won't. So from 6, respondent 6, we make a prayer that from respondent 8 to 42, we will route it to the joint secretary 6. Because the problem is that we could not get the orders, the posting orders. Where they are posted. So only the respondent, we do take some time through the secretary, joint secretary.
But subject to the other side accepting it.
My lord, it's not
My lord,
possible, my lord, if joint
No, no.
secretary,
Then your lordship,
They
the
can
address
obtain-
we have to get.
they can obtain the address from the concerned official by submitting application, my
We
lord.
filed application, they were saying that you file RTI, and once RTI is 30 days mandatory period is there, they might give name, and that's the reason. My lord. In court proceedings, we do ask. Sometimes, my lord, I think my learned friend Bora can help me out.
Your lordship
It's
may
very-
direct the official respondents to provide the address
Yes,
or.
yes, yes. That only I want. Because some might have retired also. In
The
the
official respondents are represented by you.
Yes,
So
my
if
lord.
you are directing them, what is the necessity of having the services of a learned counsel?
No, my lord, regarding the address of the private respondents, my lord, I can ask them to provide the address, my lord.
Then he can provide me, I'll take steps.
The addresses of the
You'll provide.
My lord, I cannot provide, I can ask the.
You will ask
official-
and provide, that's what.
Yes, my lord,
You don't have it with you, you'll have to ask definitely.
yes, my lord.
Then we'll immediately take steps.
That will take some time, isn't it? That will take some time, you asking and then getting and giving him all that.
Yes. That's why, my lord, if your lordship just pass an observation to provide the address of the private respondents, then probably it will be easier, because I will ask them again, they will provide it to me, I will have to provide to the petitioner, my lord.
No, it's not done like that, actually.
Bora represents the department, he can always answer.
Yes, my lord, I can do it, if your lordship directs, my lord, I will do that.
Please write, since the counsel for the petitioner submits that the petitioner does not have the postal address of the private respondents,
840.
number respondent number 8 to 42. The respondent health department to produce to furnish the detailed address of the private respondents to the petitioner, to the learned counsel for the petitioner through Mr. D.P. Bora, learned standing counsel health, within
In a week.
within 7 days.
Yes, my lord.
Stop upon receipt of the same, petitioner shall serve notice by way of registered post with ADD within 1 week thereafter. Next para, in respect of the no, you write like this, next para, also issue notice on the interim prayer, making it returnable by, you want to receive instructions, isn't it?
Yes, my lord, after 4 weeks. Yes, sir.
How much time do you require? 2 weeks?
My lord.
2 weeks? 16th,
3 weeks, my lord, 6th,
18th,
yes, my lord.
I need a date.
returnable by 18th of December 2024. Learned Standing Counsel Health Department shall obtain instructions in this regard by the next date.
Lord, Lordship is not passing. On the, at least they will not proceed, my lord. Once the promotion orders are issued, there will be again chaos. I'll have to challenge the promotion order and come. Lordship is examining this matter. These are the issues which require Lordship judicial review. Lordship. At least
We'll have to hear the other side first. Now, that's why we've given a short date.
without the leave of the, I'm not asking a blanket there, but my issue is also raising a very contentious.
Mr. Bora, then you don't issue any order.
Yes.
till the next returnable
It has
date.
been done in terms of the office memorandum passed by the personnel department, my lord. And that is being followed by all other departments, my lord. Now, and it was passed long back in the year, January 2023, my
Now
lord.
the gradation list has come, only when we are affected, we can come to that. That plea won't be applicable. At least they will not affect it till 18.
That personnel department office memorandum cannot be stayed, my lord.
No, my lord, I want a promotion, but I am not asking for a stay of the.
It is on the basis of that memorandum, my lord.
If it is in violation, it can be done, my lord. The courts are there to rectify violations. Well, Lordship will, I'll urge upon it that they will not give effect to, because they have been given 2 weeks' time. Well, 2 weeks' time, nothing is going to happen.
In that case, your lordship has to first stay the operation of the office memorandum passed by the personnel department, my lord.
No, not required.
Not
We can, you can stall the proceed as of now.
Absolutely.
Mm.
It is because I have challenged
Based on that office memorandum.
Correct, it may be based on that,
Yes, my lord.
but that office memorandum is also being challenged.
Yes, my lord.
That is why.
Well, regarding this, my lord, at the in the month of September 2024, provisional gradation list was published, my lord. So no claim or objection was raised regarding that gradation list. So final gradation list was passed there subsequently.
I've understood. See,
So-
you have made that submission already.
To that I have an
Yes, my
answer.
lord.
My lord, on 2 occasions, they never give effect to this promotion I have annexed it. Well, if he wants to say, on 2 occasions, they were giving the benefit of consequential seniority. I have annexed those officers. So we were under the feeling that this January notification will never be acted upon. It is only when the.
Okay, one more line you had. Having regard to the projection made by the petitioner, it is provided herein that any promotion that's made in the meantime will be subject to the outcome of this writ petition.
Yes, my lord.
Yes,
Yes, my
yes,
lord.
that's fine.
Obliged.
No, sir.
Yeah, please.
Yes,
Petitioner is assailing an unjustified, illegal and arbitrary transfer order.
where is that page?
Page 29 of the impugn order,
29.
page 29. In fact, it was passed within a month of the last transfer order,
It was passed
within a month of my last transfer order.
within a month.
My lord. I'll come to that, page 29.
What is the transfer policy?
My lord, transfer policy is page 31 of Annexure 6,
31 of
Annexure 6.
31.
My lord.
What does it say?
Married. Policy of transfer of officials. The state government have issued circulars from time to time of outlining the policies of transfer and posting government officials. These circulars inter alia stipulate that transferable officer and staff should normally be transferred only upon completion of 3 years of service in a particular place of posting. Whenever public interest demands that an officer should be transferred out from his place of posting before 3 years, proper justification and grounds may be recorded in writing for the transfer order issued only after getting approval of the chief minister. The government has re-examined this stipulation of obtaining prior approval of the chief minister while effecting the transfer and posting of government officers before completion of their normal tenure of 3 years in one place. After careful consideration, it has been decided that henceforth approval of the chief minister is required to be obtained only for transfer of any officer who has not completed 2 years in a particular place of posting instead of 3 years. However, the normal tenure of posting of an officer in a place of posting for 3 years will remain the same.
3 years has become 2 years now.
Yes, my lord.
Is there any approval of the CM in your case? Huh?
No, my lord. Apparently,
Who has the impugn transfer order? Page 29. And when was your last transfer?
Last transfer, my lord, I
Before
got,
this.
1810, my lord, that prior page, my lord, page 28, my lord.
You have given the details somewhere, is it?
Yes, my lord.
That
Paragraph
page
7.
in the
Paragraph 7.
synopsis.
Yes, my lord.
Paragraph 7.
Paragraph 7.
What are you otherwise?
I joined the service as excise inspector in the year 2015, my lord.
Excise inspector.
Yes, my lord. On 31/8/2015, I joined the service. paragraph 7, your lordship will find at page 8, my lord.
31/8/2015.
2015, I entered in the service.
Then what are you today? Have you been promoted?
Last order, I was promoted, my lord.
To what post?
Excise superintendent. Deputy superintendent, sorry. Lordship will see the chart at page 8.
Page 8.
8, my lord.
Where?
On 31/8, I entered in the service. 5/9, I was transferred to from Sipsagar to Mazuli. Then 31/5/2018, I was again transferred from Mazuli to Sipsagar. 9/2/2021, I again transferred from Sipsagar to BIO Guwahati. Then 11/9/2023, BIO Guwahati to Morioni. Then 3/10/2024. This is the promotional order, my lord.
310 is promotion.
My lord.
310 is promotion.
Yes, my lord. 310, the promotional order.
Court master, something's wrong with this volume, no? Where's the control? Just increase the volume. Your initial appointment is 31/8/15 as excise inspector. Promotion is 3/10/24 as deputy superintendent.
My lord. From Morioni to Hojai. In terms of that order, I joined on page 28, my lord. I joined on 18/10/2024.
Okay, so then?
Then, my lord, the impugn order has come, my lord, on 26/11, my lord. Within a month, my lord.
What is written in the impugn order? Let's see.
Impugn order is page 29, my lord. So, top of the list, my name appears, my lord.
Oh, it's a common transfer order.
I'm challenging only.
Is it a routine transfer?
My lord, only 1 month I have joined 1 month break only, my lord.
Serial, no, the first one is the petitioner.
My lord.
Where are you today?
Today I am at Hojai, my lord. I have not handed over the cert, my lord.
From Hojai, you are supposed to go to?
To Guwahati, my lord.
Or is to come to Guwahati?
My lord.
You don't want to come to Guwahati? Huh?
1 month back, I joined there and my family.
People are fighting to come to Guwahati.
My lord.
You don't want to come here.
Only 1 month, my lord, I transferred and family also set up, my lord, there, my lord. Now, suddenly, after 1 month, I am transferring again, my lord. It is not in the public interest, my lord. My respectful submission, my lord.
Yes, what do you say?
My lords have already seen, my lord, the chart, page 8, paragraph 7.
Yes.
The first 4 columns, my lord.
Hmm.
Rows, my lord, 5, 9, 16. These are all transfers, my lord, when the petitioner was holding the post of inspector of excise.
Hmm.
So he cannot project this as a frequent transfer. Firstly, those were when he was posted as a inspector of excise, and none of these orders were ever assailed by the petitioner. So the story starts from actually 3/10/2024. 3/10/2024, he was on promotion as deputy superintendent of excise. Petitioner was posted at Hojai.
Where is the promotion order?
Yes, that my lord finds
page 29.
Page 29. Not 29, but 29 is the order impugn.
Yes.
My lord finds
That
at
earlier order.
The order starts at page 21. The part of the petitioner is at page 24. Page 24, my lord.
Yes.
Fourth column, fourth paragraph, sorry. Subject to reversion without notice and without assigning any reason thereof, Sri Arun Jyoti Bharali, Inspector of Excise, Moriani is hereby promoted to the cadre of Deputy Superintendent of Excise and allowed to officiate as so-and-so, pay scale of so-and-so, pay band of so-and-so, allowances as admissible under rules, and in the interest of service, he is posted as Deputy Superintendent of Excise, Hojai, order with effect from the date of taking over of charge.
He was in Mariani.
Sorry, Moriani.
He was in Mariani, then he's been transferred to
He was in Moriani as inspector.
Inspector.
On promotion, he has been transferred
to Hojai.
Hojai.
Okay.
Then, my lord,
What is the date? This one?
3/10, my lord, 3rd of October 2000.
3/10. Let him say, submit. He's getting disturbed.
The petitioner always has a right of reply, my lord.
3/24.
Yes, my lord. 3/10/2024, my lord, he was on promotion, posted at Hojai, my lord. Then, my lord, this letter came from the Commissioner of Excise. My lord, I would like to indicate one thing, my lord. These are gazetted posts, my lord. They are under the control of the commissioner and secretary.
In the excise department, my lord, commissioner is a directorate level post who is in the field, my lord.
Commissioner.
Commissioner of excise is a directorate level post.
Hmm.
Commissioner and secretary is the government, my lord.
Yes.
Is the department. My lord. So this commissioner, my lord, of excise, Assam,
Oh.
writes this letter immediately after the promotion order, 3rd of October. He
Hmm.
writes this, my lord, to the commissioner and secretary. This is 8/10/2024. Subject, my lord, will kindly
Yes.
take note of recommendation for modification oblique transfer posting of the following post. In inviting a reference to the subject cited above, I have the honor to submit the following recommenders in the interest of excise revenue and smooth functioning of the department. Serial number, second table, my lord, serial number 1, Arun Jyoti Bharali. He recommended that the order of transfer should be modified from Hojai to EIB. EIB means, my lord, Excise Intelligence Bureau.
He's the petitioner.
He's a petitioner, my lord. Serial number 1 at second table, my lord. Arun Jyoti Bharali. The commissioner has recommended that the earlier order of transfer may be modified and he may be posted at EIB. And this resulted in the order impugnment. EIB means, my lord, Excise Intelligence Bureau.
Where is that?
It is in
situated?
Guwahati, my lord. My
Guwahati.
lord will, again, if my lord comes to paragraph 8 again, my lord. Oh, sorry, my lord. Yes, it is in Guwahati, my lord. EIB, Excise Intelligence Bureau. So, on the interest of, my lord, excise revenue, this is the team, my lord. EIB is the team that, my lord, intercepts illegal liquor trade, my lord. And the commissioner, finding him to be competent, my lord, has recommended him for this post at EIB, my lord, at Guwahati. So it's not a fresh transfer, my lord. The earlier order of transfer has been modified.
He was in Mariani as inspector of excise.
Yes.
And he was promoted to deputy superintendent of excise.
As at Hojai.
On 3/10/2024.
Yes, ma'am.
And posted at Hojai.
Yes, that order has been
And
recommended.
commissioner has recommended that instead of
Hojai.
Hojai, he should come to EIB.
Exactly, ma'am.
So on that recommendation, this
Order impugn has been issued.
impugn order has been issued.
Yes, so it is absolutely on public interest. The law on transfer is clear, my lord. Unless it is fraught with malice, statutory violation of statutory rules and fundamental rights, my lord.
Otherwise, the picture presented is that promotion and transfer happened on 3/10/24.
Immediately has been transferred.
Immediately again he's
That's
been
a
transferred.
basically an order of modification. Secondly, if my lord comes to the order impugn, my lord, as page 29, my lord. Why this writ petition in the present form is not maintainable, my lord. Page 29, if my lord peruses for a moment. My lord has seen the first paragraph is for the petitioner, my lord.
Yes.
Arun Jyoti Bharali, Deputy Superintendent of Excise, Hojai is hereby transferred and posted as Deputy Superintendent of Excise, EIB, with immediate effect. Next paragraph, my lord, you can see. In the interest of public service, Sri Dipen Bora, Deputy Superintendent of Excise, EIB, is hereby transferred and posted as Deputy Superintendent of Excise, Tezpur, with immediate effect. So, my lord, by the same order, petitioner is posted at EIB, and the person holding that post, Dipen Bora, has been transferred out from EIB to Excise.
Okay, who has gone to Hojai?
Yes, I'm coming to that, my lord. Last paragraph, my lord. 5th paragraph of the same page, my lord. In the interest of public service, Sri Prem Kumar Singh, Deputy Superintendent of Excise, Tezpur, order is transferred and posted as Deputy Superintendent of Excise, Hojai. So, paragraph number 1, petitioner has come in the place of paragraph number 2, Dipen Bora. Dipen Bora has gone in place of Prem Kumar Singh, and Prem Kumar Singh has been transferred to Hojai. These are basically, my lord, 3 persons involved, inter se transfer order. If now, my lord, peruses the cost title, none of these incumbents are, my lord, made parties.
Prem is party. Prem is party.
Secretary to the Goptava, he is not secretary to the Goptava, son, my lord.
Now,
Anyway,
Prem Kumar Singh is party.
So Prem Kumar Singh is going to Hojai in the place of petitioner.
He is party.
And Prem, the second person, my lord, paragraph number 2, Dipen Bora is going to Prem Kumar Singh's post at Tezpur, my lord. So Dipen Bora is also a relevant party, my lord. Dipen Bora has not been made.
Okay, by the way, this page 21 is annexure 3. This is the promotion orders.
My lord.
Correct. Series of promotion orders.
Yes, my lord.
Petitioner is one of them.
Yes. On promotion, he was initially posted at Hojai. That has been modified on the request of the Commissioner of Excise, purely on public interest.
Now that impugn transfer order does not mention that it is in modification.
It doesn't reflect so, but the record reveals that, my lord. Because
It says interest of public service.
that this document, my lord, is a part of the record that I have achieved today, my lord, received today.
Understand.
So
It's
record
good. It's a
reveals-
good thing you got this instruction. But I was just wondering, see, on promotion, from one place, normally person goes to another place.
My lord,
So this notification, promotion notification has placed him in Hojai.
my lord.
But then again, this November 26th notification has come.
Yes, my lord.
Number of persons are there, but it does not say anything much about the earlier promotion order
Yes.
and posting.
But it says, my lord, at the subject of that letter, my lord, commissioner's letter,
Hmm.
recommendation for modification oblique transfer posting of the following post.
That is in your letter,
True.
but not in this impugn transfer
Impugn order,
order.
it has not reflected, but
No,
the record reveals that it was on the basis of this. Record justifies this order of transfer, my lord, as a modification. And my lord, now.
So that is why that person, if he is not, if he doesn't have a copy of this record,
Yes.
how is he supposed to know?
He must be thinking that's a
Yeah,
second.
yesterday I was sent here, tomorrow they have sent me here again.
Yes.
Why they have sent me like this?
This I will bring in on
That,
record by.
that is how he has questioned by filing this writ petition.
Yes, sir. That I will bring on.
Now the answer now is that there was some requisition of your services.
So take note, my lord, that notification I have pointed out at Annexure 6, my lord,
Hmm.
whether there is any approval of the chief minister or not.
My lord, on that, my lord, I have a submission to make. My lord. Page 31 is the notification, my lord will see. That's the OM.
Mhm.
It's the transfer policy of transfer of officials. I am not disputing anything on this, my lord. Yes. Usually a person, if he is to be transferred, he should not be transferred within 3 years. And if it is within 2 years, the concurrence from the Honorable Chief Minister is required. Exactly identical case, my lord, was filed before this Honorable Court, my lord. Challenging an order of transfer on the ground of being violative of this OM.
Okay.
And the division bench of this Honorable Court has held this OM is not binding. It's a guidance to the government and it will not give rise to any right to a person who is on transfer, my lord.
I am not exercising the
So
right.
even if, my lord, we are not following this.
Lordship will take note, my lord. 1 month I have joined at Huzai, my lord. I have shifted my family to there. My son, my children are also, my lord. Now, after 1 month, I am transferring to Guwahati. And the Lordship will see, my lord, in the last 9 years of my service, my lord, I have been transferred 6 times, my lord.
No, earlier transfers were on, my lord, when he was a post of inspector,
my lord,
and none of those transfers were ever SL.
I'm probably I'm showing, my lord. In the 9 years, my lord, I've been transferred for 6 times. Out of 6, only 1 is transfer, promotional transfer.
Well, if I may conclude, my lord.
Yes.
But on this OM, my lord, the earlier OM that preceded this OM, my lord, there was a case. Only 3 paragraphs of that judgment, right? It's a division bench judgment. Whether if this OM is violated, my lord, whether it will give a right to the petitioner to SL an order of transfer, my lord. 2011 4 GLT 7 to 4, my lord. Paragraph 2, my lord, just for the facts of that case, my lord. It's a division bench order, my lord. Paragraph 2, by the aforesaid impugn order, the learned single judge has stayed the implementation of order dated 11/7/2011, passed by the Secretary of Government of Assam Water Resource Department, transferring the petitioner respondent number 1 from the office of Guwahati East Water Resource Department to the office of the Superintendent Engineer Monitoring Evaluation Cell Guwahati. Now, my lord, if we come to paragraph 13 of that judgment, my lord. Oh, sorry, paragraph 12, my lord. 12, my lord, 1-2. It is a settled position of law that an order of transfer of a government officer is no doubt justifiable, but such transfer orders can be interdicted in writ jurisdiction in rare and exceptional cases. Broadly, a transfer order can be interfered with if such order has been issued by an authority not competent to do so, if there is violation of any statutory rule, if there is gross discrimination between the writ petitioner vis-a-vis similarly situated officers, employees, and if the order of transfer is actuated by any mala fide. Paragraph 13, my lord. In the case before us, neither is there any challenge to the competency of the appellant to issue the transfer order, nor is there any allegation of violation of statutory rules. There is also no allegation of discrimination between the petitioner and similarly placed officers. Precisely the same situation, my lord. Precisely, the impugn transfer order has been assailed only on the ground of non-adherence to the OM dated 4/2022, which stipulates 3 years as the normal tenure of an officer employee at the particular station. It has also been pleaded by the writ petitioner that no region has been assigned to transfer the writ petitioner from one office to another within a short period of 6 months. The other ground to challenge the transfer order is that the same has been issued at the behest of the Respondent number 3 Minister of the Department, and as such, it amounts to mala fide action. Now, my lord, coming to paragraph 16, my lord, sorry, 14. An identical issue of transfer of an officer from one office to another in the same station at Guwahati, and that too before the normal tenure of 3 years came up for consideration before this court. In the case of Ranjit Chandra Burman, Supra, in the said judgment, a division bench of this court has held, when the order of transfer to another office is in the same place or station, judicial intervention may not be justified to such transfer
You are
order.
reading from which part?
Paragraph 14 of that judgment, my lord.
Okay.
Or, my lord, let us directly go to no, my lord, paragraph 14 is relevant, my lord.
Same station.
Same station. That's the court part, my lord, quotation part. When the order of transfer to another office in the same place or station, judicial intervention may not be justified to such transfer order for alleged breach of the prescribed norms of recording justification. In this judgment, this is relevant, my lord. The division bench had also taken into consideration the observations made by the Honorable Apex Court in the case of Union of India versus S.L. Abbas, reported in 1993 for SCC 357, that there is no obligation for an employer to justify through reasons an order of transfer. An interference of the court in the transfer order on the ground of lack of assigning reasons would be unjustified. In this case also, the Honorable Supreme Court was considering the transfer order of an officer in violation of government guidelines, which provided posting of husband and wife at the same place as far as possible. Their lordships observed that while ordering a transfer, there is no doubt the authority must keep in mind the guidelines issued by the government on the subject. However, the guidelines do not confer upon the government employee a legal enforceable right. Now, my lord, coming to paragraph 16. In the case of state of UP versus Govardhan Lal, the Honorable Supreme Court reported in so-and-so, AR so-and-so, Honorable Supreme Court was confronted to examine a transfer order, divorce the government order laying down norms and principles for regulating transfers, and observed as for below. It is too late in the day for a government or servant to contend that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in the terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contra in the law governing or conditions of service. Unless the order of transfer is shown to be an outcome of a mala fide exercise of power or violation of any statutory provision, an act or order, or passed by an authority not competent to do so, an order of transfer cannot lightly be interfered with as a matter of course or routine as for any or every type of grievance sought to be made. Even, my lord, this is very relevant, even administrative guidelines for regulating transfers and containing transfer policies at best may afford an opportunity to the officer or servant concerned to approach their higher authorities for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer servant to any place in public interest, and as if found necessitated by exigencies of service, as long as the officer's status is not affected adversely and there is no infraction of any career prospect, such as seniority, scale of pay, and secured emoluments. This court has often reiterated that the order of transfer made even in transgression of administrative guidelines cannot also be interfered with, as they do not confer any legally enforceable rights unless, as notice supra, shown to be vitiated by mala fide or is made in violation of any statutory provisions. Paragraph 22, my lord. Paragraph 22, it is true that unwarranted transfer of an efficient and independent officer is against good governance. At the same time, bringing more efficient and competent officer to man a particular post or a particular exigency is also a part of administrative management and good governance. The role of judiciary in such matters is very limited. The legal principles in this regard have already been decided. Same reiterations, my lord. So even if, my lord, there has been infringement of this OM, my lord, that will not give rise to a right to the petitioner to assail it. And here is a case, my lord, one of the person who is directly affected, whose post he is going to occupy, my lord, he has not been made a party respondent.
No.
He has not been made a party respondent, my lord. So he, being a necessary party, my lord, in his absence, my lord, any order, including an order interim, my lord, will not be, my lord, may not be justified, my lord. And I have already placed that requisition of the Commissioner of Excise. There is nothing to indicate any malice, any favoritism, any discrimination. It is purely on public interest. We think that petitioner is more competent to handle that post at Excise Intelligence Bureau.
Okay.
I'll place the record, I'll file affidavit if needed, man.
Look, can you see the impugn order is placed 29 again? As my learned friend is saying, my lord, it is a modification to the earlier order, my lord. Nothing is indicated, my lord. It is a press notification dated 26 November 2024.
That I only pointed out
Yes,
to the council.
And the last.
You're telling me
paragraph-
what I had stated.
Yes, my last paragraph, my lord, that the person.
How long
who
will
is
we
coming-
keep? Huh.
The person who is coming to my place, my lord.
Yes.
Prem Singh Kumar Singh.
He's a party.
Yes, my lord, he is a.
But not Dipen Bora.
Dipen Bora, my lord, he is going to Trespoor. He is not affecting my place, my lord.
Just say.
We'll issue notice, that's all.
My lord,
No
my lord,
interim.
I'll be prejudiced.
I'll
my lord,
produce a
because-
record by Friday, man.
Because, my lord, and Lordship will, he is producing the records, my lord. There is
No,
there
see,
is no approval of the chief minister also, my lord.
maybe.
It's not always
My lord.
required, man.
Although I am not gathering in right in terms of the notification, my lord.
No, prima
Approval is
facie, it
there.
doesn't appear that there's malafide
Yes, man.
on the transfer.
Well,
I
only
cannot-
1 month, my lord, I stayed there, my lord.
We can, that's why 1 month, nothing happened. It's like you were a guest there only.
No, my lord.
It was modified basically.
My-
Modified.
My family, my lord, I have transferred there, my lord. I settled only.
Everybody is rushing to
Now
Guwahati,
I am
my lord.
coming to Guwahati, my lord. And Lordship also seen, my lord, in last 9 years, well, I have been transferred 6 times.
Yes, I've heard you. I'll pass the orders. Heard Mr. P. Hazarika, right? P. Hazarika, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the notification dated 26/11/2024, bracket annexure 5, by which he has been transferred from Hojai to Guwahati. Stop. The learned counsel submits that the petitioner was initially appointed as excise inspector on 31/8/2015. And thereafter promoted to the post of Deputy Superintendent of Excise. Void notification dated 3/10/2024. Stop. On his promotion, the petitioner has been transferred from Mariani to Hojai. Stop. However, barely within a month of his posting to Hojai, he has been transferred out to Guwahati by the impugn notification. Stop. The learned counsel submits that the petitioner has been transferred frequently for as many as 6 times during his service career, ranging from 5/9/2016 to 26/11/2024. And the last transfer order has been made. In violation of the existing transfer policy of the state government, issued by Office Memorandum dated 6/8/2013 by the Department of Personnel, bracket B, Government of Assam. To stop, he therefore submits that the impute notification dated 26/11/2024 be state. Mr.
P.N. Goswami, my lord, as additional AG.
Additional
AG.
Mr. Next para, Mr. P.N. Goswami, learned additional AG, appearing for the official respondents at this stage by producing a communication dated 8/10/2024 issued by the Commissioner of Excise not issued, sent by the Commissioner of Excise to the Commissioner and Secretary to the Government of Assam, Excise Department, submits that purely due to exigency of service and in interest of the public, a recommendation was made to modify the transfer and posting of the petitioner from Hojai to Guwahati. And therefore, there was no malafide involved in posting the petitioner to Guwahati. Now, by referring to a division bench judgment of this court in State of Assam versus Dilip Kumar Sharma and others, 2011, 4 GLT 724. The learned additional AG submits that the transfer policy by itself does not confer a right upon the government servant to remain in his choice of posting. Unless it is a case of discrimination, malafide, unless it's a case of discrimination or malafide reasons that such transfer has been made. So he further submits that by the challenge made by the petitioner to the transfer notification dated 26/11/2024. 3 persons, including the petitioner, are to be affected. And the petitioner has only impleaded. The respondent number 4. Who is required to replace him in Hojai? But he has not impleaded the person who has been transferred from Guwahati. Next para. In view of above, let notice be issued, returnable. How long?
Any date, ma'am. I will bring the.
Can you expedite your affidavit so that we can take a decision?
Yes, then my lord may fix it before vacation, my lord. Let it be
Returnable by,
My lord,
returnable by 16 or 18?
18, my lord.
16, my lord.
16 is okay, my lord.
Returnable by 16.
Public.
Mr. P.N. Goswami, learned additional AG accepts notice on behalf
1,
of,
2, and 3.
of respondent numbers 1, 2, and 3. While anybody else?
4 is the private.
Okay. And therefore, no formal notice will be required. Petitioner shall serve requisite extra copies of the writ petition to Mr. Goswami. Stop petitioner shall take steps for service of notice upon respondent number 4 by registered post with AD due within 3 days. Considering the urgency expressed by the petitioner, the court, the respondents should file their affidavit by the next date so that an attempt can be made to final dispose of the writ petition.
And we'll also place on record the relevant records. Of
Yes, the official respondents shall also place the relevant records on the next returnable date.
Oblige. That will be more quicker, man. Oblige.
May I please?
Yes.
Well, this application is filed for impeding the my lord opposite party number 1 of this IA as respondent number 4 of the my lord contempt petition.
Who's the applicant?
My lord.
Petitioner. Applicant is the petitioner.
No, my lord, applicant is the my lord petitioner. My lord. Applicant is the petitioner, my lord.
What have you filed? You have filed contempt petition.
My lord.
And you want to implead one more person here.
Yes, your lord.
Who is the person you want to implead?
Respondent page number 2, opposite party number 1, my lord. Kirti Jalli, IS.
Whom do you want to implead?
Kirti Jalli, opposite party number 1, my lord.
One is already there. How can you implead one?
My lord, the one, my lord, regarding this IA, my lord.
Who is the original respondent number 1?
Original respondent number 1 is the my lord, Mr. JB Akka, IS in the contempt petition.
Yes, altogether there are 3 respondents.
My lord.
Okay, why do you want to implead this new person?
My lord, because my lord, earlier, my lord, the respondent number 2 of this contempt petition, my lord, Mr. Joy Sivani, he was replaced by this, my lord, opposite party number 1, my lord.
Why do you want to complicate things? You see, there are 3 persons already there.
My lord.
Let them remain as number 1, 2, 3. You want to implead new person, let him be respondent number 4.
My lord.
Isn't it?
My lord.
What do you say? Your good name, heard, Mr.
M. Islam.
M. Islam, learned counsel for the petitioner, applicant, sorry, who submits that by filing this application, the applicant seeks impleadment of Srimati Kirti Jali, IAS, the Commissioner, Panchayat and Rural Development, Assam, as respondent
Number 4.
number 4.
This contempt.
Since she is the new incumbent
My lord.
holding the state post. What is your good name?
P. Thapa.
P.
Thapa.
And you are appearing for?
Respondent number all, for all respondents.
PNRD, my lord.
PNRD.
But this is contempt. You have to appear by way of your power.
So on behalf of S. Datta, I am appearing.
As Datta appearing for all the respondent. my
For all the respondents.
Notice is yet to go. In advance, you've got instructions to appear. How is that?
In contempt, we are appearing, Lordship.
Other respondents already noticed, my lord, served, my lord. For 1, 2, 3 of this contempt petition, my lord, notice has already served. And
What is your name? Miss
P. Thapa, appearing on
Miss
behalf
P.
of
Thapa, learned counsel, appear on behalf of
S. Datta.
Mr. S. Dasta, submits that she has no objection to the prayer. To stop in view of above, the application for impleadment is allowed. IA stands disposed of. Then in the contempt, you write, in view of the order passed today, in IAC number 3595 of 2024, Srimati Kirti Jali, IAS, Commissioner, Panchayat and Rural Development, Assam, is impleaded as respondent number 4. The petitioner shall submit amended cost title in 2 sets before the registry within 3 days. Next para, issue notice to the newly impleaded respondent number 4, returnable by 4 weeks. Miss so-and-so, learned counsel, appears on behalf of so-and-so and submits that she has instructions to appear on behalf of the newly impleaded respondent and prays for some time to file her power. Praise allowed. List the matter again after 4 weeks. Respondent number 4 may file show cause reply in the meantime.
bless you.
Not may, you write in respondent number 4 to file. To file, not may. Instead of may, you write to, TO2.
Please, your lordship, my lord, this is for impleadment of respondent number 3 and 4, my lord. 1 and 2, my lord, they have been changed, my lord. Can you see page 11?
Yes, impleadment of respondent number
3 and 4.
3 and 4. Where's the name?
Page 11, my lord. Para 5.
How many respondents earlier?
Yeah, 1 and 2, my lord. Now 3 and 4 in their place.
Okay. Third, Miss A. Khatun, learned counsel for the applicant, who submits that by filing this application, the applicant seeks impleadment of Sri Govind Mohan, Secretary to the Government of India, Ministry of Home Affairs, and Lieutenant General Vikash Lakhera, Director General Assam Rifles, as respondent numbers 3 and 4 respectively. So the learned counsel submits that impleadment of the 2 persons is required as they are the new incumbents holding their respective posts as stated. And for effective compliance of the court's direction. In view of above, application for impleadment is allowed. IS stands disposed of. Then in the main contempt, you write, in view of the order passed today in ISC number 3616/2024, Sri so-and-so, Lieutenant General so-and-so, are hereby impleaded as bond numbers 3 and 4, respectively. Petitioner to submit the amended cost title in 2 sets before the registry within 2 days. Issue notice to the newly impleaded respondent, returnable by 4 weeks. Petitioner to take steps by registered post with ADT within 3 days.
This is your lordship. Lordship, the respondent was supposed to file their affidavit in opposition, lordship, in this matter.
Which respondent?
Then three, Lord.
Who's the counsel? Notice is complete?
Lordship, they have not impeded the current income then, lordship, they need
Huh?
to impede, lordship,
You are appearing for whom?
for the lordship. Respondent number 2, lordship,
Who's respondent number 2?
the director of health services Assam, lordship.
Dr. N. Lakim.
Yes, lordship, but currently, lordship, he has been retired, lordship, he has retired, lordship. So they need to impede the current incumbent, lordship. I'll give the details, lordship. And there was an order to that extent as well, lordship.
When did he retire?
About, lordship, 1.5 years back, lordship.
So why was the court not informed then?
Lordship, I had informed, lordship, there was an order on 14/8/2023, lordship, maybe 14/8, lordship,
So there's a direction to him to obtain necessary instruction whether the contemners were still in the concerned post. So that direction probably he has received. And that particular order was with regard to the reinstatement of the petitioner. That has not been done. So long back the order was passed. In the year 2021, then submitted the representation, now almost 3 years. The period is already over. There was an extension period of 2 years for correction of the date of birth and accordingly reinstating the petitioner. There's an order was passed on 20/12/2021. The lordship kindly see the contempt petition in page number 40. There was a specific
And
direction.
lordship, that too also, lordship, I have an instruction, lordship, that.
What is the order to be complied with?
Yes, page number 13, lordship, of the contempt petition. The operative portion is at page number 14. In that view of the aforesaid admitted position, this court is of the view that the petitioner has the right of consideration for correction of his date of birth, inasmuch as the petitioner had applied for correction of his date of birth in due time, that is prior to 3 years from the actual date of superannuation. Therefore, this court proposes to dispose of the present petition in the following term. The petitioner within 10 days from today will file a fresh representation along with his proof of actual date of birth before the Director of Health Services. On receipt of such representation, the director shall, with 4 weeks thereafter, pass a speaking order regarding the correction of the date of birth. In the event the date of birth is corrected, the petitioner shall forthwith be reinstated in service, and in happening of such event, the director will consider the grant of back wages to the petitioner and pass a reasoned order. So that was passed way back in the year 2021, lordship.
And lordship, there
Immediately
was a
thereafter submitted the representation, but nothing has happened.
Lordship, thereafter, lordship, I have received instruction, lordship, as he was directed to file a representation, fresh representation. That representation has never been filed before the Director of Health Services, lordship. I have that instruction. I have just now placed it, lordship. It is of 2/3/2023.
No, he was directed to file fresh representation.
Yes, lordship.
No,
That was
accordingly it
never
was filed,
filed, lordship.
Huh?
That was never filed, lordship. The 14/8, lordship, order is very much clear, lordship.
What is this page 16 then?
Lordship, there is no seal, nothing, lordship.
Lordship, that seal I'm having on the last occasion, I also made a prayer before this honorable court. And this representation I'm having where this seal of the concerned authority is there, lordship.
But lordship, he has not annexed it with this.
That was not
petition.
annexed, but the
So-
concerned contemner was aware of the fact that they had received the representation. And lordship can peruse the representation, which was accordingly.
Now, how did you serve the representation?
The lordship kindly see that particular representation.
How did you serve?
Personally serve, lordship. That was served in the
How?
office, and accordingly the concerned, because the concerned petitioner cannot directly meet the contemner, so it was given to the office, and accordingly office had received the.
No,
copy of the-
director will be having a PA.
Yes, lordship, that was given to the PA, lordship kindly.
So why don't you get the signature, the seal from the PA?
It is there, lordship, just now I've given it, lordship.
But
Because
not-
at that point of time, at the time of filing, this particular representation was not in my hand. So the representation which was having Accordingly, I filed it along with that particular representation, but later on I received the copy and on the 30th 12, within the stipulated period of time, the representation was submitted. And they are having the knowledge about that, Lordship.
No, having the knowledge and all that, leave that aside. See, at the first instance,
Yes, Lordship.
whenever you're filing this kind of petition, you must ensure that you annex a copy of the receipt so that we don't have to later on
No.
ask everyone and ask you also again, go and look for it,
I
ask
can-
your clients.
Exactly, Lordship.
Straight away, you should just annex it.
Lordship can take judicial notice of this particular representation when the seal and signature is there. And that was duly received by the concerned authority, Lordship. Even after receiving that particular representation, they have come up before this honorable court saying that they have not received. So this is something not correct facts narrated before the court. And the government advocate was there, he had communicated the order, knowing fully well that this order has been passed to reinstate. There is a clear violation of the direction of this honorable court, Lordship.
When did you file the contempt?
That was filed on 23rd of February 2022, Lordship. Because I waited for that time frame that they were supposed to dispose of my representation within a specific period of time, after 4 weeks.
No, what has happened to your date of birth? Has it been changed?
Nothing has happened, Lordship.
It's not been done.
Nothing has happened.
Who's supposed to do
No
it?
reinstatement, nothing has happened.
Who is supposed to do it?
The director. The contempt on number 2.
Who's the present director?
Lordship, he is Dr. Umesh Pangsu.
He's not a party?
No, Lordship, they will have to impede, Lordship.
That is one thing.
Yes, Lordship. And Lordship, I'll get question whether that representation has been received or not, Lordship.
New person will come and go every time.
Yes, Lordship.
But what did the old director do?
He did nothing, Lordship.
Lordship, he has written, Lordship. Thereafter, Lordship, he has written to the government, Lordship.
Where?
On 3/5/2023, Lordship. Lordship, that instruction, Lordship, I am having one copy, Lordship.
What is this letter received from the Standing Council Health?
Lordship, of 2/3/2023, Lordship.
No, that the contents of this letter.
Lordship, that was, Lordship, one.
Just listen. Number one is that he says that we have not received a representation. But secondly, he says that I have received a letter from the Standing Council Health. So I'm writing to the government what to do.
Yes, Lordship.
What is
because
that letter?
That letter is, Lordship, once the writ petition is disposed of, the council has informed the department that this.
That information.
Yes, Lordship,
Okay.
that. But they have not filed any representation before us, Lordship.
This letter says that he has not received the copy of the representation.
This should kindly see the representation. I'm having the copy which I have received from the concerned
Let it
office.
be on record.
The seal and signature.
Get it on record, Lordship.
They are aware about the order, Lordship. These are all technical things, whether I filed the representation or not. But since I filed the representation, now they are saying that they have not received. But at the same time, they can act upon that. Because there is a specific direction to comply with the order and within a stipulated period of time. Now, since my learned friend is appearing, he can obtain the necessary instruction from the concerned authority now, the director, whether the court, this concerned authority is intending to pass any order in view of the direction given by this honorable court.
Please write Mr. D. Upamanya, learned counsel for respondent number
2, Lordship.
2 has produced a letter dated 2/3/2023 written by the Director of Health Services to him stating that representation has not been received from the petitioner. in terms of the court's order dated 20/12/2021 in WPC number 2307 of 2019. Stop. However, Mr. S.P. Chaudhary, learned counsel for the petitioner, has produced a copy of the representation wherein there is a round seal of the directorate dated 31/12/2021. Acknowledging the representation of the petitioner. Stop. Mr. D. Upamanya, learned counsel, submits that he may be given some time to obtain instructions in this regard. Stop. He also submits that the respondent number 2 has since retired.
Retired, Lordship.
Retired, and there's a new incumbent holding the post of Director of Health Services. Stop. The petitioner may consider impleading the new incumbent. List again after. Two weeks. You're in touch with the new director?
Yes, Lordship.
You ensure that matters complied with what
Yes.
is there.
Yes, Lordship.
See, we cannot go and on like that. Because this round seal also is a round seal department. You may go to any section and get it done. It's not that the director and the PA, PS with the name they have signed.
Lordship, that copy may be furnished to me so that I can inquire whether it has been received by them or not. Because since it is not on record, Lordship, I may be allowed to have a copy of that.
You share your copies with list again after 2 weeks
Lordship, can a date be fixed?
on 18th.
Lordship, the petitioner may serve me a copy of that.
Copy of what?
Of that representation with seal and
Yes,
sign.
you serve him. Do I have to indicate?
Yes, Lordship, that will be Lordship,
Huh?
helpful for me.
Not required. I will serve me a copy.
You Xerox and give him.
Yes,
What is there?
just xeroxing and giving.
But main purpose now is that you instruct your director to do the needful. Let us not go into the nitty-gritty, who has received, who has not received. Okay.
Yes, Lordship. Spelling to highly obliged.
That was what item? Number? Just now? 46.
May I be before, Lordship?
Yes.
My lord, I'm sorry, my lord, this is regarding restoration, my lord. The matter was relating to pensionary benefits, my lord. On the day when matter was called, my lord, I could not be physically present, my lord. And unfortunately, I could even not connect through VC also, my lord. That time was, my lord.
Okay, what is this IFO?
Restoration, my lord.
Yes, any objection? What is the ground of your restoration?
My lord, two consecutive days, my lord, I could not physically present, my lord. So, my lord, when the matter was fixed again, my lord, I was trying to connect through VC, my lord. But unfortunately, my lord, that time was in Corona period was also there, my lord. COVID-19, my lord. So, my lord, because of that situation, my lord, I was totally handicapped, my lord. So, my
Which
lord,
is the order?
Lordship, I have an next, my lord. The order. The next one, my lord. Page 10.
This is for delay. Condonation of delay or restoration. Your restoration application is within time. Is it filed within time? There's a limitation also. How much is the 1 month? 30 days. Dismissed for default on 10/2/2022. Correct. And your restoration application filed on? my God. You missed something.
My lord, lordship may confirm.
You have to file a condonation application. You only say 30, you say 30 days, isn't it? To file restoration application, you have to file it within 30 days.
Yes, yes.
You have filed this beyond 30 days. It was dismissed on 10th of February 2022. Your restoration application was filed on March, the month of March. March, in fact.
I think I'm on time, my lord.
How? Calculating. What are you busy calculating?
My lord, I was just looking the calendar, my lord.
You have been absent many times.
2 consecutive days, my lord.
Not only 2 consecutive times, even in the writ petition, many times you have, even in the IA, you have been absent many times. What is the point of restoring now? Again, you'll be absent tomorrow.
My lord, this may not be happen, my lord.
Is there any merit in your case?
My lord,
Any cause of action survives?
It's regarding my lord pension, my lord.
Maybe Petitioner does not want pension. You're not appearing. All right, you're Mr.
My lord, NK Modi, my lord.
But Mr. NK Muri, learned counsel for the applicant who submits that by filing this application, the applicant seeks for restoration of the writ petition, which was dismissed for default on 10/2/2022. Stop referring to the application. The learned counsel submits that when the matter was listed on 10/2/2024, the petitioner, the counsel for the petitioner was attempting to appear through video conference. But however, due to technical problems and despite all efforts, he could not get the connection. Stop. As such, the writ petition was dismissed for default. Stop. He submits that since it was for bona fide reasons that the petitioner could not, the learned counsel could not appear on that day, the order of dismissal on default may be recalled and the writ petition be restored. Stop. Mr. D. Bora, learned counsel, appearing for the state, submits that he has no objection if the writ petition is restored. Next para, upon hearing the parties and on perusal of the application, the applications seeking restoration of WPC number 3947 of 2019 is hereby allowed. I stands disposal.
I am obliged, my lord.
Then in the main, you write, in view of the order passed today in IAC number 1004. I'll repeat, IAC number 1004/2022. The writ petition is restored to file. What is to be done
My
in
lord,
the writ petition?
let it come for admission.
Let the matter be listed for admission. Affidavit has been filed.
Affidavit has been filed by the Assam State Agricultural Marketing Board. They have their own standing council. Because the petitioner was working there.
What about state? Any role?
We don't have that much of a role because.
List the matter again after
Vacation, my lord.
after the ensuing vacation
I am obliged, my lord.
on a date to be fixed by the registry.
May I please, Lordship?
Yes.
Lordship, kindly adjourn the matter for the day, Lordship. My senior Miss A. Gayan has undergone through a surgery, Lordship.
She has undergone surgery.
Surgery, Lordship.
Miss A. Gayan, learned counsel appearing for the petitioner is said to be indisposed on a prayer made on her behalf. Matter stands adjourned.
P. Rabha, Lordship. P. Rabha on behalf of Mrs. A. Gayan.
Adjourned for how many days?
For 3 weeks, Lordship.
What surgery? It's a minor surgery.
Tumor surgery, Lordship. Uterus.
Tumor surgery. After 3 days, she can come back.
3 weeks, Lordship.
Oh, 3 weeks. Yes. Okay.
Lordship, we have taken steps for respondent number 1 and 2, Lordship. And there is an interim order, Lordship. That may be continued.
When did you take steps?
Lordship. After 6, Lordship, we have taken steps.
No. It does, office note says no steps taken.
Lordship, some time may be granted, Lordship, so that we can verify, Lordship.
If you don't take steps, this will be dismissed on the next date. It is seen that the petitioner has not taken steps despite the order dated 6/9/2024. As paid for by the learned counsel, appearing on behalf of Ms. A. Gayan, a week's time is granted to take steps for service of notice to the respondent. List the matter again after 3 weeks.
Lordship, interim may be
Interim
granted.
order passed earlier shall continue till the next date of listing.
Please, Your Lordship. My lord, we have filed the instant case for review of the order of this honorable court, my lord. But there is a delay of, my lord, 365 days, my lord, or 63 days, sorry. So in this regard, my lord, notice may be issued in the IA, my lord.
More than 1 year.
Nearly 2 days left, my lord.
Oh, 2 days left.
2 days.
65, 63, right.
Actually, my lord, what happened, my lord, I have engaged a counsel, but I don't know, my lord, why he did not appear and did not pursue the matter, which subjected to the affair also and complaint to the bar council.
Okay, heard Mr. J.I. Barbuya, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 363 days delay in filing the connected review petition. Issue notice returnable by 4 weeks.
I'm appealing for respondent 1, 2, and 3, Lordship.
1, 2, 3, and 4, director.
1, 2.
1, 2, 3, and 4.
Headmaster also.
Headmaster 1, 2, 3, Lordship.
1, 2, 3.
Mr. Your good name?
T. Thakuria, Lordship.
T. Thakuria.
Yes, Lordship.
Mr. T.
Secondary
Thakuria,
education.
learned standing counsel,
Standing counsel, secondary education.
secondary education, appears and accepts notice on behalf of respondent numbers 1, 2, and 3. Petitioner to take steps, applicant to take steps for service of notice upon the respondent numbers 4 and 5.
Returnable date may be fixed, my lord. Any date after 4 weeks. First week of January.
Then, on the 30th of November, my lord, there was an order, my lord. Your lordship will find that order page 7, my lord. There's a typical error, my lord, in that order, page 7. Just pass by, lordship. Page 7 of my IA, my lord.
Yes, page 7, I've got it.
And page number 9 is the relevant portion, my lord. Lordship will
9.
find. Page 9, my lord.
Yes, which paragraph?
Para 4, my lord. Para 4, last 2 paragraph. Till disposal of the representation, the respondent should insist the petitioner to proceed to Punjab Abohar. My lord, it ought to have been, the respondent should not, my lord. Only the word not is appearing, and for that, my lord, the entire meaning has been changed, my lord. Because I was actually checking for an interim, my lord, protection. And while considering that prayer, my lord, I think it's a typical error, my lord. Only that word, my lord.
Yes. This is a clerical mistake. Heard Mr.
MA Islam.
Islam.
MA. And my lord, one more correction. Para 2, my lord, only one date. Actually, the battalion of the petition was shifted, my lord, on 20th of October, as per my read petition also. But here, my lord, it is written as 21st of October. Only, my lord, this to be corrected as 20, my lord.
Where?
Para 2, my lord. Page 8, para 2, my lord. In the middle portion,
Ah,
the how about the in which the petitioner is serving has been worked to Punjab Abohar on 21st 10 2024. It ought to have been, my lord, 20th, my lord, not 21st, my lord.
it ought to have been
The 20, my lord, 20.
20,
10 24, not 21st, my lord, not 21, my lord,
20, 10, 24.
21.
Is it like that in your writ petition?
Yes, my lord.
Show me.
Synopsis also, my lord.
No, not synopsis.
Lordship.
Main.
My lord. Para 8, of my petition. Second line, my lord.
Okay, please write. Heard Mr. M.A. Islam, learned counsel for the applicant. Who submits that by filing this application, the applicant seeks correction of the typographical mistake which has appeared in the order dated 13/11/2024 in WPC number 5844/2024. Stop referring to the date 21/10/2024. This will be within inverted comma, which appears in the 7th line of paragraph number 2 of the said order, and also you cut that. Which appears in the 7th line of the said order. The learned counsel submits that it should read as open inverted comma 20/10/2024 instead. Full stop. He further submits that the sentence in paragraph number 4 of the said order should read as open inverted comma till disposal of the representation comma the respondents should not insist the petitioner to proceed to Punjab Abohar. Close inverted comma. Full stop. Close inverted comma. Mr. Barwa, any submission?
No, I have no submission. My name may be recorded.
Yes. Mr. DC Bora.
PC Bora.
Mr. DC Bora, learned CGC appearing for the respondents submits that he has no objection if the typographical mistake oblique error which has occurred is corrected. Full stop. Next para, in view of above, the date within inverted comma 21/10/2024 appearing in paragraph number 2 of the order dated 13/11/2024 should read as open inverted comma 20/10/2024 close inverted comma, and the last sentence in paragraph number 4 should read as open inverted comma till disposal of the representation comma the respondents should not insist the petitioner to proceed to Punjab Abohar close inverted comma. The IA stands disposed of as allowed. Stop. This order shall be read as part of the order dated 13/10/2024 in WPC number 5844 of 2024.
Highly urged.
Then you write one more line. My lord.
May I please, your lordship?
Yes.
My lord, this IA is filed by the petitioner lordship for condemnation of delay for filing the connected miscase lordship for restoration of the contempt case lordship, which was dismissed for default the order date 21/3/2018 lordship. The delay is of 1584 days.
Where is the order?
Lordship, order is in miscase lordship at page 13 lordship of party portion. Page 12 is the starting of the order. Yes, lordship, but
2018.
2018 lordship, but I was
Why
not-
do you want restoration of this?
lordship, because the lordship claim which was done by the petition lordship in the read petition lordship, the direction that was not complied by the authorities lordship. And in the meantime, lordship, while I have handed over the brief lordship to the council lordship, he even not communicated with me lordship.
Have you thought of filing a fresh petition instead?
Lordship, fair petition lordship may not be lordship like, because lordship, well, already an order passed by this court lordship.
What was the order?
So only restoration may be restored in the file lordship thereafter. Because that order is of 2013 lordship.
Which is the order not complied with?
That read petition, order of the read petition.
Who's the petitioner? What is he?
Lordship, he is serving as a doctor lordship,
Serving as a
medical officer lordship.
medical officer. Even today also.
Today also.
And what is his prayer?
Lordship, that prayer regarding lordship, unpaid salary lordship.
From 95 to 2000.
Yes, lord. And that was already considered by this honorable court lordship, directing the authorities to take the appropriate steps lordship. And when that was not complied lordship, the petitioner filed the contempt case lordship. But that was also lordship showing to be dismissed for default lordship, for non-prosecution. But that was never been informed to the petitioner lordship. By the council.
You have not been vigilant with your case, isn't it? You have
Lordship,
not been vigilant.
I have repeatedly communicated with him, lordship, but he could not inform anything, lordship, about this.
What is the ground taken by you?
Lordship, in the IA lordship, I have stated lordship at paragraph 3 lordship.
You think court will condone the delay with this kind of statement?
Sorry, lordship. Because lordship, I could not able to put any documents regarding that part, lordship, because the lordship, I have asked my client lordship to communicate, but that lordship, very council lordship, even I have not known to him lordship. But who is that?
No. See, there's no problem. We'll issue notice, but ultimately, what will happen to your case? You have not given proper explanation. How do you think court will condone the delay like that?
I have given the explanation that till the June 2024 lordship, I have no knowledge about the case lordship. Because in the meantime, I have communicated on several occasions, Lordship, with my engaged counsel, Lordship. The applicants have engaged the counsel after giving his fees as required, and it cannot be presumed that the applicant should watch the everyday proceeding. The code shown. So that is the reason, Lordship. Even Lordship, the petitioner is in a Lordship helpless justice seeker. He is helpless because Lordship is a justice seeker, but due to fault of his earlier engaged counsel, Lordship, he has been suffering.
In the contempt case, you have seen the respondent number 2 file affidavit in opposition. Correct?
Yes, Lord.
You claimed for continuous service from June 1995 to 7/11/2000. But the respondent says that there's no records available in the office about your service. So on what basis you're going to claim?
And along with the salary, Lordship, because I have produced every documents, Lordship, which is very much available in my writ petition.
Where is that document?
That documents, Lordship, along with this case, Lordship, I have not annexed. That was available in the writ petition, Lordship. That
No, there's nothing actually.
at this stage, Lordship, your Lordship may kindly issue notice, Lordship. Thereafter, if required, Lordship, I will produce those.
No point giving false hope to your client. That is what I'm saying. Notice may go, it'll be pending another 3-4 years. What will happen? Nothing will happen. Your client has not worked anything. He's not worked. Had he actually worked, I think definitely they would have considered and given him. Respondent number 2, Deputy Secretary has filed affidavit. Anyway, heard Mr.
NH Borbu.
NH Borbu, yeah. Learned counsel for the applicant who submits that by filing this application, the applicant seeks condonation of 1584 days delay in preferring the connected miss case number 80 of 2024, seeking restoration of the contempt petition number contempt case C number 184 of 2015, which was dismissed for default. On 21/3/2018. And who was this? Who are these respondents? They are the current respondents. Manish Thakur, Santana Chetia, Dr. Ratindra Bhuyan. Are they still serving?
They are not served.
Then
They are not in office.
how will you restore it? How will you serve notice?
Because Lordship, this is the problem actually, Lordship. I cannot file impleadment petitions.
Huh?
I cannot file impleadment petition also, Lordship. Because
So what is the point of issuing notice? These people will not receive any notice because they're no longer there. That's why I told you, it's better you withdraw this and file a writ petition, fresh one.
My lord, writ petition may not be entertained because lordship,
Why?
this is the old salary case, lordship, because this is regarding payment of salary till 2000, lordship.
Sorry?
Lordship, this is the unpaid, regarding unpaid salary, lordship. So now that might not be considered, lordship. Because,
Why not?
because this is the salary of 2000, lordship, 95 to 2000.
So?
Is the old salary, lordship, and dishonorable court, lordship, in last occasion, lordship, there are so many judgments are there, lordship, that
Which
after
says
3
that?
years, after 3 years of lordship, that unpaid salary, lordship, the claim cannot be made. So for that, this is the problem, lordship. Otherwise, lordship, I will
No,
file the file.
your case is different because your case was disposed of
Yes, sir.
by this court. Correct?
Yes, sir.
When was it disposed of? 2013?
2013. And the case was of 2004, lordship. That's WPC 7935 of 2004. At this stage, lordship, if your lordship please to lordship restore the contempt case, lordship, then I may able to implead them, lordship. Because this is the because contempt case is no longer in file, lordship. So I am not able to file the impleadment petition also. This is the critical situation because lordship, they, yes, yes, because lordship, the earlier parties are no longer in office, lordship. So now I could not able to lordship serve them copy, lordship. Or lordship, your lordship may grant the liberty to the petitioner, lordship, to for filing a writ petition, lordship. That also cannot be, lordship, because there is already an order, lordship. There is already an order, lordship, of this honorable court, lordship.
But it does not been decided on merits, isn't it?
Yes, lordship.
Supposing the court has decided by way of a judgment and order, with reasoning everything and decided, if you go again, second time will be barred by res judicata. But if the matter is not decided on merits, you can try your second
But
round.
there is a direction, lordship, to them. So may pray, lordship, if your lordship please to restore, then lordship, I may implead them.
I
lordship,
cannot
the
restore it just like that, Mr. Counsel. You
because
know very
otherwise,
well.
lordship, I have no other option, lordship.
So you
Because-
think about it, cancel the order as paid for by the learned counsel for the applicant, matter stands adjourned. You just think about it for the day.
All right. Third,
Other side is served notice, they may not have any objection. Lordship, both the counsel
and the party was suffering illness. Medical papers I have annexed.
This is the first time.
First time.
Notice will have to go.
Notice, need not, the delay may be content, I have already served them, all the department, no private party. Lordship, this is a matter. 133 days, I have explained meticulously, both medical papers are given, both the.
Yes, what do you
counsel
say?
and the party. Yes, I have filed, I has been filed.
In this, I have to find first, I for condonation of, not in this particular, they are asking me for condonation.
No, two filing is there, one I have for condonation of 130 days, 3 days delay.
There is Mr. Borough.
Yes.
IA 3663 is for condonation of delay. And the other miscase is 82 is for restoration.
Lordship, medical papers, annexed to onwards, Lordship. Counsel was ill on that day, and the party could not visit the chamber. He was also suffering from illness, medical.
Who are the respondents? Finance, Public Grievance, Inspector General Registration,
Everybody is.
then Secretary Revenue, Disaster Management.
Similar issue was long time pending before the division bench, now it is. resolved.
Don't pass any document right now.
Lord.
Who's appearing for the other side? Anyone? Yes. You have any objection to the condonation? If there's no objection, then we'll dispose of this matter.
I may be disposed of.
We'll thrash out the matter on merit. Okay. You are Mr. Mr. R. Islam, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 133 days delay in filing the connected restoration application, that is miscase C number 82 of 2024. Mr. The learned counsel, by referring to the application, submits that it was on account of the medical condition. Whose medical condition? Counsel or the applicant himself?
Applicant is filed.
No, medical condition.
Both the counsel and the applicant, both.
Counsel also was sick. Applicant also was sick. Both of them sick together. Huh?
Lordship, what to do?
What to do? Okay.
That was the unfortunate.
On account of medical condition of the counsel for the applicant as well as the applicant himself.
Annexed 2 and 3.
Mr. The learned counsel submits that unless the delay is condoned, the applicant shall suffer irreparable loss and hardship. Next para, Mr.
S. Dutta.
S. Datta, learned counsel appearing for the
1 and 4.
respondent numbers. Who's 1 and 4?
Revenue and disaster management.
Learned counsel appearing for the revenue and disaster management respondents submits that he has no objection if the delay is condoned. He submits that the matter may be considered on merit. Considering the submission made, the delay of 133 days in filing the restoration application stands condoned. IS stands disposed of. Then miscase. In view of the order passed today in IAC number 3663 of 2024, condoning the delay in filing the instant application, the application is taken up for consideration.
At the hearing stage, it was.
What is the ground you've taken?
Found the ground of illness of the.
Again, ground of illness.
Same.
Next time, don't be ill, okay? You have to take medicine, tablets, everything properly and come.
Sir, one.
Mr. R. Islam, learned counsel for the applicant, by referring to the application, submits that the case was dismissed for default at the stage of hearing. So he submits that in view of the illness of the engaged counsel, he could not appear before the court when the matter was called. And therefore, the writ petition was dismissed. He submits that for the fault of the counsel for the applicant oblique writ petitioner, the petitioner should not be penalized. He submits that otherwise, in view of the bona fide reasons for the absence of the appointed counsel at the relevant time, the writ petition may be restored to file. Mr. S. Datta, learned counsel appearing for the
Revenue and Disaster Management Department.
Revenue and Disaster Management Department. Who else? Miss. Your good name? Miss A. Sharma, learned counsel, appearing on behalf of Mr. B. Chakrabarti, standing counsel, AG Assam, also has no objection. I have no objection to the prayer for restoration. In view of above, the application seeking restoration of the corrected writ petition is hereby allowed. This case accordingly stands disposed of. Next, in the main writ petition, in view of the orders in view of the order passed today in Miss Case C number 82 of 2024, the writ petition is restored to file. Place the matter when?
The month of January.
After the
7th January, it should be on a hearing date.
Place the matter again after the ensuing winter vacation on a date to be fixed by the registry. Okay, let them fix. Yeah. This case, writ petition is restored. This case and I disposed.
Well, the affidavit has been exchanged. On last occasion, my friend submitted that their scheme is being framed, my lord, regarding commission appointments. Initially, this institute was under the Government of Assam, then it was under NEC, then lastly, Government of India has taken over under the Ministry of Health, my lord, Government of India. Now, my lord, the problem is that there are 180 persons of applicants for commission appointment. They have not given them. They said that I have appointed a contractor and you work under them, and finding no other alternative. We have been working since last 10 years under contractor, my lord. But we are getting minimum age only, salary, my lord, minimum pay scale we are getting. That's why we have come before it. I have come that commission appointment may be made. Yeah, I think scheme has been framed, my lord. My friend is here.
Yes,
indeed. This is autonomous body, my lord, registered under the society, where he was his father was working, my lord. That we have no such scheme for compassionate appointment, and to save from the hardship, we requested some agencies who are working in the engaging in the LGBT institute, my lord. I requested them to engage him as worker. And I have stated in my affidavit in opposition in para 8, my lord.
Whatever might be the fate, but we are willing to work.
But he is getting everything, my lord. He is getting well, and his mother also getting the pension, and one brother is elder brother is also a government servant, my lord. 8, my lord.
So what is to be done?
We have we informed them, my lord, earlier, my lord, that we have no such scheme.
What is that society or what?
My lord, it is now under the Institute of Government of India, my lord.
Under the
autonomous status. It is under Medical Institute, my lord, postgraduate studies.
What is the name? What is the name?
Mental Health Institute of Assam.
Locopriya Gopinath
Mental Health,
Bordore,
Gopinath Bordore.
Regional Institute of Mental Health.
Regional Institute of Mental Health.
Yes.
Where is it located?
Registered society, my lord.
Where is it located?
Yeah, Tezpur, my lord.
Tezpur.
Tezpur.
Okay.
It was
But your lordship knows Sheila Batse's case. Sheila Batse. That is from Tezpur Mental Hospital.
My lord,
Regarding the discomfort situation of the patients, my lord. Ultimately, it is under supervision of what High Court, my lord.
not Supreme Court. My lord.
Supreme Court, my lord.
My lord, this was initially a mental asylum under the government of Assam, my lord. And Sheila versus had preferred an PL in the Supreme Court. Supreme Court directed to a Constitutional Commission to inquire into the matter, my lord. And direction was given to this honorable court also to observe the matter. And they rescued some person from the asylum, my lord, because the government of Assam has violated the human rights. Government of Assam also, behind the back of them, 288 person was released from the various jails and mental asylum. And thereafter, my lord, as per the direction of the apex court, my lord, BOA was running that institute, and it is converted to a institute, my lord. It is now pursue the research and all.
Tezpur.
Tezpur, there is a postgraduate
Yes.
studies center.
Yes.
Postgraduate studies center.
People are going there. Doctors are going there for post graduation.
Yes, yes, yes. Then now it is 150 years. One of the oldest institute of Asia.
So now, but there's no compassionate appointment
Well,
scheme.
no. There is the institute initially it was under Government in Assam. At that time it was there. It was under NEC. It was there. Now they said they don't have. Now they have framed the other time they have submitted before your lordship that we are framing the scheme. Now, all right, we will work under the contractor, but service is very uncertain. We may be kicked out anytime. That's why. If they give us assurance that no, you will never be disturbed from your service, then whatever meager salary we are getting, we'll continue considering it is our fate, my lord.
Petitioners are working under the contractor.
Contractor, that is
As what?
as a daily wages.
My lord, contractor, my lord, there is no
Crores of
category
rupees
depots,
they are paying to
group
contractor.
depots, my
Crores
lord.
of rupees every month. Crores of rupees as salary.
At 7, my lord, at 7, para 7 of my affidavit.
Affidavit money, it is there.
Para page 22, my lord.
It is under Exam Venture Limited, my lord,
Of Bengaluru.
Yes.
a Bangalore-based company.
As a Chandigarh. He is getting ESI, everything, medical and everything. And 8 is that a Samgong scheme compassion, is it not?
Yes, they
It is
must
not-
give us assurance that we will not be disturbed. But it is the fate of 180 persons, my lord. They are working daily as a group D worker. Can they deny that they are not central government? They are under central government.
No,
It is fully
Samgong-
financed by the Government of India. Fully financed.
Yes, my lord, it is true that financed by the government, Ministry of Health and Welfare, but it is a society, my lord.
The society, what happened? All
But
colleges and
we
society.
are not same putting it central government employee, my lord. We are not central government cadre, my lord. And if 10 said that in absence of a scheme of compensation and appointment, the institute is not in a position to engage him or regular basis like other similar cases mentioned in the previous annexes. And the petitioner is getting insufficient. He is saying that he is not getting any insufficient, he is getting insufficient amount. The amount which is drawn by him is as per notification of the government of India. Moreover, the family of the petitioner is drawing family pension at the rate of 4,370 plus JNS relief at the rate of 119% and 6,000 medical allowance per month. Moreover, the elder of the petitioner is also a state government employee.
So we'll post the matter after some time for hearing, not today.
Yes, ma'am. Well, we only want, my lord, if they don't initiate any scheme, my lord, then it is a question of fate of the 180%, my lord. They should not kick out us.
There's only one petitioner before this court.
We are working under the contractor now. Contractor is collecting our salary from the from the institutes,
No.
and he is paying us.
One petitioner is not we. Petitioner is single.
Yes, now he is only alone. Other have not turned up, but it is the case of that man. They let them deny, man. There are no 180% are there. They have not turned up. Out of fear, they may be kicked out. That's why.
So when do you want it?
We have no schemes, sir.
Huh?
Because of the
No, we will work under him, my lord, but we should not be disturbed. That is how. We work. What to do? They should not disturb.
Come
If this
under
contractor goes, next contractor will come.
Ministry of Health Department, Family and Welfare Department in the year 2007, my lord, from NEC. And we have no scheme, and we are not getting, we are not the
My lord, nowadays,
similar with the
nowadays what happened?
central
Most of
government.
the institute, they are, say, it's like banks, my lord. Bank are given up the scheme of competition. They'll pay us, I will giving you 10 lakhs forever. Most of the banks are doing, but they are not, now they are hoping that because there is requirement of the employee, so they are engaging for contractor, so that they may be saved from money, my lord. Anyway, when we consider it is our own fate, my lord, we'll work under contractor, but if tomorrow we will be kicked out, my lord, that is the fear, my lord. We should not be disturbed.
Contractor is not a party here, na?
Contract is not a party. Contract, every year it will change because there is a tender.
How will
No,
Mr.
they have to
Datta,
assure. My land.
how will Mr. Datta undertake that they will not kick you out?
That is the problem, my lord. Then why
Contractor is not there, na?
we may give up the idea of the competition appointment, but we should not be disturbed in future, my lord, because it is a tender process, my lord. Every year there is a new tender, new contractor will come. Last 10 years we have not been disturbed because one contractor goes, another contractor comes.
We'll post it after 2 weeks then.
Yes, I have got no problem.
Okay, that's paid for by the parties. This is the matter again after 2 weeks.
Right. Let it be parted, madam.
Not parted.
Let it be parted, madam.
No, not parted.
Lordship, in this matter, as per the order dated 9/8 of 2023, we had communicated to the BTC department as regards the genuineness of the candidate. But I believe that the BTC has not reverted back to us.
What is the matter about? What is the matter about? Genuineness of the appointment of the petitioners.
Obtain instruction, Lordship, after 2 weeks, Lordship.
The last occasion, Lordship, they sought time for 4 weeks, Lordship.
Lordship, it is,
It's in the month of September, Lordship.
also I shall obtain the instruction after 2 weeks, Lordship. I am applying for the first step.
Attention of the court has been drawn to the order dated 9/8/2023 and 30/9/2024. So, Miss
Lordship, I'm appearing for the health department. M. Huya, Lordship.
M.
M. Huya.
Mr. M. Bhuya, learned counsel, appearing for the health department, as well as Miss R.B. Bora, learned counsel, appearing for the BTC respondents. Pray for some time to obtain instructions in the matter. Yes, prayed for. This is the matter again after 2 weeks.
Lordship, Lordship.
I think I'll not be able to finish it anyway. I'll do one thing. Yes, the remaining matters will be taken up on some other dates. We're out of time today.
Item number 45, my lord. Today was for consideration of the interim order, learned senior advocate, my lord, Mr. K.T. Pathak leads me.
45.
45, my lord. My friend is also here. Since it's for the consideration of the interim order, my lord, could it be taken up on Thursday, my lord? There was a request on that.
Surely.
All right.
See, the urgency matters, court master will give the dates.
Alright.
And please indicate it if there's any interim order, that also will be taken care of. But depending on the fixation of case,
Okay.
we'll give that priority. So that we don't bunch up all the cases in one day. Okay?
Item.
You get the dates.
Item 38 is regarding suspension. It was not reviewed within 90 days.
You get the dates. Today is not possible.
No.
Item 38.
Restated.
Influx was because the final order of DP has already been passed, my lord.
You have the order?
Where is the no copy served to us? Even the party.
You have extra copy?
I will serve him the online
Take
copy.
up
Soft copy.
on that.
Do one thing, we'll fix it again on Wednesday or something.
Yes.
You make
Copy to me.
you make extra copy.
Yes, I have soft copy. I use
Soft copy, hard copy is required. Soft copy is.
No, we'll have it on Wednesday.
Why?
Okay.
You are terminating or whatever.
Still, Lordship may kindly fix the matter on Monday, my lord.
Next
wait,
Monday.
coming Wednesday?
Yes.
My lord. Wednesday, I have some difficulties, some part-hard matters. Tuesday, yeah,
Thursday, nahi to?
Thursday.
On Thursday.
Thursday.
You give the date for Thursday, okay? Just give him the dates.
I've got a prayer for item number 41. Can it come up next Wednesday or Monday as it is convenient for the audience?
Surely, I've already said, you please indicate to the court master. He'll give you the dates. All right? And if there's an interim order, please indicate.
There's no interim order then?
Okay.
Oh, no, Lordship.
All right.